Good afternoon, and welcome to the Appellate Division First Department. Today we have over 8 hours of argument time requested. So, as I call the calendar today, please only request the time, not that you want, but the time that you need to make your most salient arguments. You already know that this bench, we've read your briefs. We're familiar with the underlying issues of your appeals. For those of us who may be here for the first time, the white light on the lectern will go off when you have 2 minutes left, or if you've requested less than 2 minutes, it will go on immediately. When the light turns red, that means your time is up. Not for the panel, we may have more questions for you. And certainly, if the panel has further questions past your allotted time, we will keep asking them and you will have an opportunity to respond. When I call your case, please rise and tell us who you represent and how much time you are requesting. People v. Jonathan Cedeno. Submitted. Fields versus Julius Liberty Development. Let's go with the appellant first. Thank you. No, it's no problem. How many that you need? I see. Okay. Now, you did file a reply. You want rebuttal time? 5, 2, 5. R. Dana is submitted. Rieta, if I'm mispronouncing that, please correct me, versus Schulman Properties. Okay. All right. 5252. Gray versus Nassau Life Insurance. Mm-hmm. 525. People v. Loris Morales, and they're all going to be heard together. Submitted. Scott and Scott versus Kaplan, LLP. Okay. 525. Anonymous versus Anonymous. Mm-hmm. 624. Aveson Young, NY versus 459 West 50th Street.
For appellant, 5 and 2, please.
Mm-hmm. 525. Hanold versus City of New York.
The appellant, Your Honor, Jim Wagner, 5 and 2.
523. Gopstein v. Vod. Uh-huh. 525. People v. Tariq M. is submitted. Will of Lillian M. Rach.
For appellant, Your Honor, 7 and 2.
Responding cross appellant 7.
626. Lexington. 6262. Thank you. Lexington Insurance versus New York Marine. Mhm. 626. Stewart versus JMDH Real Estate.
For construction resources, respondent, 5 minutes.
All right. 625255. Miller versus State of New York. Mhm. All right. Okay. 727, OCA, 5 minutes, and the amici, 4 minutes. People v. Michael Martin. Six to six. Josie versus New York City Department of Finance, that is submitted. The first case on the calendar, we're going out of turn, will be Miller versus the State of New York. The court is granting the request of counsel to be heard earlier. There's a personal matter that must be addressed, and Justice Gesma is recused. People v. State, excuse me, Miller versus State of New York. Thank you.
Good afternoon, Your Honors. May it please the court. First of all, thank you for granting my request for a preference and argument. David Scharf, on behalf of the appellants Miller, Monteleone, and Marazzo. Your Honors, the ERA makes clear that you should not face ageism, sexism, or racism in your employment, whether you are a DMV clerk, a state prosecutor, or a judge. And the fact that we're here debating whether it's acceptable for the state to retire judges based upon the 19th century mores that a 70-year-old was too feeble to adjudicate matters shows how deep-seated ageism is within our society. My clients are...
So counsel, it seems to me that you're arguing that the job eligibility shouldn't matter. It's just a matter of the age discrimination?
No, to make sure I understand what Your Honor is asking me, we believe that judges need to be qualified and competent to perform their duties. We are arguing that the constitutional provision that says judges that are 70-year-old must retire and can no longer serve once they reach the age of 76, no matter what their term for election is, based solely upon age, is discriminatory and inappropriate under the new ERA. And we must re-examine what has been a precedent where previously age was not a protected class, was not a civil right in New York, and which had previously permitted the mandatory retirement age both in the Constitution and in our judiciary law to stand. This case requires a re-examination of that.
So you're saying that in light of the Equal Rights Amendment, that prior attempts at raising the mandatory retirement age for judges should be disregarded by this court, and we should look at this anew?
Yes, Your Honor.
And let me add to that, the sponsor memo on this was silent as to age.
The sponsor memo went across the board and enumerated multiple categories, including sex and sexual preference,
But did it include age, counsel?
but the statute included age, and the statute put age in there together with race, religion, and everything else that was added. And the notion that we can stratify a class that was put in as a part of a broad sweeping amendment that was designed and was marketed, in essence, to the electorate to be something that would remedy a wrong, address invidious discrimination that has gone on historically, including ageism, to treat it as a protected class.
Counsel, where in the legislative record, does it support your position that the intent of the ERA was to, impliedly repeal, Article 6, Section 25B?
It is two pieces, Your Honor. It is the broad language and the mandate that the voters and the state legislature put in place. But most importantly, when we look at the critical language where it talks about the prohibition of discrimination and the creation of civil rights pursuant to law.
So is it to follow then, based upon what you're seeking here, that there is just no age requirement that can be placed on any position that's being held by any state individual?
No, Your Honor. We are not looking to say that every single age-based determination is discriminatory. We are simply focused on the fact here that when there is a constitutional provision and a law that says you must retire because you're of a particular age, and that harkens back to the 1800s when you look at the legislative history of what was happening in the 1870s, they were enumerating the feeble-mindedness of people in their 70s. We've come a long way since then, and we have in place not just hundreds of years of judicial examples in the federal court system, but we know just from our own certification process that we have that there is a better way in order to be able to make determinations who should be sitting on the bench. Those are the people that are elected, the voters. When they elect people for 14-year terms, if they're somebody up the age of 65 is up for election and running against somebody who's age of 40, that could be a campaign issue. But when the voters elect somebody who for a 14-year term when they're 65 years old, then they should be able to serve that out. And we should not say, just based upon your age, without any reflection on competency or qualification. Nobody is standing before.
But the certification process, doesn't it allow for a review of competency?
It does. It does. And although the certification process is something that we are challenging and we are claiming violates the ERA, we are not saying that there could not be a certification or a review process for judges to ensure that they are competent and qualified to continue to serve. We have that as it relates to the ability to remove. We have a commission that addresses competency. But to say age for the sake of age, that violates and goes directly contradictory and cannot be reconciled with the ERA that has now elevated age to be on the same level as every other protected right.
Voters of New York State, how have they reviewed this particular issue in the past? Have they had the opportunity to review age requirements, eligibility for judicial offices?
Yes, many years ago, there was a discussion relative to whether or not the age should be raised. But here, we're dealing with something much broader. We're dealing with a policy issue, and I recognize my time has run.
I'll let you finish that sentence.
Thank you. We are dealing with a broad public policy mandate, and the New York Court of Appeals has said, when we are dealing with a broad policy mandate, the way we did in the Vulgar case, that we recognize that the breadth of what we are trying to encompass, unless specifically exempted, which was not the case here. It could have been, the amendment could have written and said, except for judges, but it did not. It included everybody and everywhere that you could not have it, therefore they're irreconcilable. I'll reserve the rest of my time for argument. I thank the panel.
Thank you. We're now going to hear from the New York Civil Liberties Union.
May it please the court, Jessica Perry for the New York Civil Liberties Union Foundation. In this appeal, the lower court's interpretation of the ERA would render it meaningless, and no different than Section 11.
On this particular issue of the retirement age of judges, or whenever retirement age comes into play?
On the, it would render it meaningless as to the ERA as a whole, for any classification, age or otherwise. And the reason why is because the way that the court decided this, it determined that Section 11 is essentially no different than it was prior to the ERA. This would be devastating for any ERA claims going forward, and we strongly urge this court to make two essential clarifications to the lower court's order. One, the ERA provides a legally enforceable cause of action for New Yorkers against discrimination for each enumerated classification. And two, the standard of judicial review courts must apply when interpreting ERA claims going forward must now be, at minimum, strict scrutiny. To be clear, even though this case is about age, this would have wide-ranging impacts for any of the enumerated classifications for sex, for abortion, for LGBTQ status, and more. The lower court is also an outlier amongst other Supreme Courts to have reviewed these issues. There are two other Supreme Court cases we know about. One is Williams that we cited in our brief, and the other is a new case that was decided since briefing was done in this case. That case is Saltarelli. That's out of Madison County. And in both of those cases, the courts concluded that the ERA did something, not nothing. They also found that strict scrutiny was likely the appropriate standard of reviews. We point the court to those cases. Our amicus brief expands on these arguments, and I'm happy to take any additional questions the court may have.
Any questions?
No.
Thank you very much.
All right, thank you.
May it please the court, Esther Merdukaeva for the state respondent. Petitioners contend that Article 6, Section 25B has been repealed by New York voters and can no longer be enforced despite having been in effect in every version of the state constitution since 1777. Supreme Court correctly rejected that argument and concluded that the ERA did not repeal Article 6, Section 25B. We urge this court to affirm on that ground. The New York Court of Appeals has never found a constitutional repeal by implication. It has always been express. And even in the legislative context, the Court of Appeals has warned that implied repeal is heavily disfavored and can only be found with clear intent to repeal.
So what was the legislators' intent in approving this amendment?
Well, Your Honor, I think that's a very broad question, and I don't think your honors have to answer that question at that level of generality in order to resolve this appeal.
Okay.
To resolve this appeal, you would only have to decide whether the ERA was intended to repeal the judicial age retirement provisions in Article 6.
So is there any proof that they did not intend to repeal that?
There is no proof in either direction, but that cuts in favor of the state, Your Honor, because to find an implied repeal, there really does have to be some sort of affirmative proof of an intent to repeal. And we know that doesn't exist here for a few reasons. First, the judicial age retirement provision is not the only age provision in the Constitution. There are also constitutional provisions setting a minimum age of 30 to be governor or attorney general or lieutenant governor. There's no indication whatsoever that the voters thought that college students should now become eligible to run for governor because of the ERA. But if the petitioners are right, and the ERA did repeal every age-based classification in the Constitution, that would be the necessary
Is there anything in the legislative record that would give us an indication as to whether or not they intended the amendment to apply to judicial retirement age?
There is no such indication, Your Honor. So once you have no indication, that should be enough itself to reject the implied repeal argument. You can also reject the implied repeal argument because courts have found implied repeal exists only if there's such a strong repugnancy between two provisions that the two cannot possibly coexist.
Should we consider the fact that there have been legislation introduced by the Assembly and the Senate to repeal the retirement age?
Yes, absolutely, Your Honor. That seems like clear evidence that the ERA was not intended and did not repeal the Article 6, Section 25B, because it's very strange for the legislature to propose new repeals of those provisions if they thought the ERA already accomplished that. There was nothing ever communicated to the voters about the effect of the ERA on the judicial age retirement provision, which is important because Your Honor is right. In 2013, that exact issue was presented to the voters and overwhelmingly rejected.
What is your response to the arguments that's been posed that the ERA is self-executing and should be subject to strict scrutiny as it relates to age?
Sure. I will say at the outset, Your Honor, and at the risk of belaboring the point, I do not think Your Honors have to reach those questions in order
Why
to
is
resolve
that?
this appeal. Because this appeal can be resolved simply by finding that the ERA did not repeal Article 6, Section 25B, because both can be given meaning. And therefore, the court would not need to reach the question of whether the ERA is self-executing and what level of scrutiny applies.
Are you suggesting that we issue a declaration that the ERA just does not apply?
Well, Your Honor, if you conclude that the ERA did not repeal Article 6, Section 25B, that is enough to affirm the dismissal of the petition in its entirety without saying anything else about the ERA. And we do urge the court to refrain from saying anything about the ERA if you agree with us about the implied repeal question. Those are both questions of first impression. The ERA is a new amendment. There are already cases raising similar questions. There will be other cases raising similar questions. And we think the appropriate way to resolve those issues are in cases where the issues are squarely presented and necessary for the resolution of the case. Here you can find that there's no implied repeal because there's no indication of intent to repeal. It is also true that the two provisions can be harmonized. The Section 11 has always been interpreted as having an equal protection clause and a civil rights clause. The equal protection clause was not amended and has already been interpreted by the Court of Appeals as not prohibiting the mandatory judicial retirement age. That case law remains binding on this court. The Civil Rights Clause has been interpreted to prohibit discrimination in civil rights. And as we've argued in our brief, constitutional qualifications for public office are not the type of civil right that is implicated by the Civil Rights Clause. You don't need to say anything about employment being a civil right because that's really a different context. In this context, the question is, does somebody have a civil right to hold a public office that is constitutionally created without meeting the minimum qualification requirements? And they do not.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. Pedro Morales for the Office of Court Administration, Counsel's Office. The Office of Court Administration does not take a position as to whether the ERA rendered the mandatory retirement age unconstitutional. We are focused solely on the issue of whether a preliminary injunction, an application for a preliminary injunction was in fact denied, and it's our position that the court below did not abuse its discretion in denying that application, and for two reasons. One is that OCA is not an entity from which an injunctive relief can be obtained. A preliminary injunction is designed to protect the status quo, preserve the status quo so that an entity like OCA does not take any action that might impair a final judgment before the merits are reached. Here, the appellant, Miller, sought a preliminary injunction preventing his retirement upon reaching the age of 76. I submit to the court that OCA is not in a position to take any kind of action that would impair such a final judgment with respect to that, because OCA does not have any power to maintain appellant Miller in his position after the age of 76.
By law, you're compelled to tell him, you got to go.
Right, we are not in a position to keep him in office. We can't keep him in office after the 76, after he hit the 76 age period. So on that ground, OCA cannot even be enjoined from taking any kind of action. In addition, there was no insufficient showing that a preliminary injunction was warranted here, and primarily because Justice Miller was not able to establish that he would suffer any irreparable harm. Here, the harm that he is pointing to is that he would lose his position upon December 31st of 2025, the year that he turned 76, and would no longer be in office. Irreparable harm is typically harm that cannot be compensated monetarily. With respect to Justice Miller, upon the loss of the end of his term as a justice, if it was turned out that the mandatory retirement age requirement was determined to be unconstitutional, and that Justice Miller was in fact improperly
reinstated.
Right, improperly handled, treated, he would be entitled to be compensated for his salary and any benefits that he would normally earn. If there are any other questions, Your Honor, I rest on the brief.
All right, thank you very much.
Thank you.
What was sold to the public was that...
Counsel, can I interrupt you for a moment? Can you respond to your adversary's argument regarding implicit repeal requiring repugnancy?
Yes.
And that repugnancy be so palpable that both can't exist together?
Yes. I was heading in that direction, so the answer is absolutely. I'll just get there a little bit sooner. We aren't saying that there is a right to continue to be a judge. We are saying that the ERA says that as a state employee, these judges have a right to continued employment that is free from discrimination. And when you have a general provision, this is right out of the SEMO case, a later general provision where supersedes a prior specific one where that conflict is irreconcilable. And what that means is that to be free from discriminatory disqualification for public service, that extends and means where no actually means no. No discrimination has to mean, based upon age, cannot be, well, we're going to look at something else and we're going to carve it out, because there is no express exception.
Have they tried to carve it out when they introduced those bills in the legislature?
No, for the ERA amendment, there was absolutely no even attempt to consider a carve-out. It was sold, as I was saying, as something very, very broad, and it's shocking that those who were there selling it are now saying narrow it because somehow if we're going to try to reconcile it, we're going to split hairs between equal protection and civil rights, when the court has said the equal protection rights here have been elevated to the point where they are a civil right in order not to be discriminated.
But isn't that a part of the legislature's intent that we should be looking at? What is it that they try to do when they pass the ERA?
And what they were looking to do, and I recognize my time is run, if I may answer the question.
And then I have a question after that.
Sure. Is they were looking to a broad array of suspect classes that would be treated, as we argue, based upon strict scrutiny, that could not survive a situation where we're simply telling somebody, you're completely competent, but you're too old. And that's what was argued. A qualification, the state just argued, a qualification was you're too old. You don't meet the qualification based upon the fact that you've aged out.
Counsel, please tell me, why can't the two sections be, harmonized? Why can't the Civil Rights Clause and the Equal Protection Clause be harmonized?
Well, the Civil Rights and the Equal Protection Clause, we believe, protects our client, both of them. There has been an attempt to split the hairs and say that the Equal Protection Clause is the old Equal Protection Clause. When we look at the bill and those who introduced it, and what they were trying to accomplish was broaden the Equal Protection Clause. What is happening here, the state is looking to hold on to vestiges of the old for judges, but move forward for everybody else, leaving judges behind who are completely qualified to continue to serve.
Thank you very much.
Thank you, Your Honors.
Fields versus Junius Liberty Development, LLC. Oops. Good afternoon.
Good afternoon, Your Honors. May I please the court? My name is Christopher Lawrence Parisi.
You speaking to the mic?
Absolutely.
Problem. Thank you.
Good afternoon, Your Honors. My name is Christopher Lawrence Parisi, and I'm with the law firm of Gallo-Vitucci Clark, and we are here today on behalf of the defendant, Appellant Junius Liberty. Today, this is a labor law case.
Right.
Yes,
So we're in agreement that this is a labor law case?
it is a labor law case.
All right, so tell us, why isn't the plaintiff involved in, protected activity? I mean, certainly, he was repairing a ceiling leak, cutting a hole in the ceiling, sheetrock knife, electric saw, and so.
Well, Your Honor, the main basis of our argument is the routine maintenance defense. As we all know, the routine maintenance defense is an exception to the labor laws in general and the labor law 240 subsection 1. In this case, we have a major issue with the non-party witness testimony.
So let's go back. So you're saying that someone that cuts a hole in the ceiling, sheetrock knife, an electric saw, that is routine maintenance. That doesn't fall within 241.
What I'm saying, Your Honor, to be specific, we have to talk about the circumstances of that cutting, because in this case, we have the non-party witness who testified that the cutting may have happened 2 days before the accident, and he didn't even know who did the cutting. Now, that's a major issue in this case.
He also, did he say that he didn't know if plaintiff did it on that day?
Yes, he said he's not sure if the plaintiff even did the cutting. That's in the non-party witness testimony.
I'm not sure that's accurate, because we're talking about Bishop, right?
Correct.
Right. And I thought he testified that he didn't see plaintiff cut. So that's a little different than, what you're suggesting.
He didn't know one way or the other.
He didn't know one way or another.
That's speculation on his part that it wasn't plaintiff.
Speculation, but now the major issue...
Let's go further, because, there's also the testimony where Bishop said that he could have cut earlier that day. That's a little different than what you're saying.
Well, he said multiple times, I think 3 times in his deposition, that it happened 2 days prior, that he believed it happened 2 days prior. Now,
He believed.
He
He didn't say that he was there and he saw it.
Well-
He didn't know one way or the other. So maybe we should move away from Bishop and we'll talk about what the plaintiff was actually doing, right? Because if we're going to be talking about routine maintenance, we're going to be talking about significant physical changes and configuration. The cut, and we saw the pictures, right? The cut-in of, why don't we talk about that?
Well, I would just like to add, which is very, very important, the plaintiff's testimony unequivocally is that he is the maintenance supervisor. The morning he was asked to look for this leak, his testimony is that he goes, he gets Wesley Bishop, his subordinate, him and Wesley go up, I believe they check the leak, they see the leak, they have to get tools. He says they go down, they get tools, they pick a ladder, they get a sawzall, They go back up. He testifies that Mr. Bishop is with him this whole time. I know you want to talk about the pictures and the holes, but we're going to talk about the making of the holes first.
Well, I mean, if we're going to talk about the making of the holes, and if you're, as according to what you're saying, Bishop was with him the whole time, then how can Bishop say that he doesn't know one way or the other when that hole appeared?
Exactly, because there's a major, major, major contradiction which gives rise to an organic issue of fact in this case. This case, you can't make a determination.
What's the issue of fact?
Yes.
Well, the issue of fact is that the plaintiff says he has Wesley Bishop with him. He says, there's all this testimony about this procedure they go through where they go, they're working Unit 614 on the 6th floor. So he's saying they go up, they find what's going on, they do this, they do that, they come down, they get all these tools. He testifies to all these tools.
Did Wesley, and maybe you can point to me in the record where it says this, because I might have missed it. Did Wesley Bishop say that when he was on this inspection, as you put it, with the plaintiff, that there was already a hole there?
Yes, that's exactly what Wesley Bishop says. That's why we have such a major issue here, because the plaintiff's...
But he didn't know when that hole got there. It could have been there 2 days before. Or it
Correct.
could have been there by plaintiff before he
had no idea.
got Bishop with him. If he had no idea, how is that not speculation as to, I don't know, how do
Because the
what
plaintiff-
weight do we give that? What weight
plaintiff has-
should that be given on a summary judgment motion?
Sorry, Your Honor. The plaintiff has married himself to Wesley Bishop in terms of the testimony here. He's saying, okay, I go that morning, I do all this stuff with Wesley Bishop, we do a ton of stuff, we get a ton of tools, we go up, and you saw the picture, that said they cut a ton of holes. I mean, that must have taken a while. It's a pretty, a sizable area. So now you have Mr. Bishop who testifies, I didn't see any of that. I wasn't with him for that.
No. Mr. Bishop said, I thought that was done a couple of days before the accident, but then he admits plaintiff could have cut the ceiling open earlier that day. Why isn't it speculation, like my colleague is saying?
So I tell you what, you have a chance to answer that on rebuttal. We're now going to hear from the other side. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Jesse Mink for Mr. Fields. To address...
So why isn't Bishop's position enough to raise some issue of fact as to credibility?
Well, if you assume either is true, meaning Mr. Bishop's, you called it speculation, I'll stick with that as to the time that the hole was cut, he didn't know whether Randy did it or not. Randy said he did it. All other indications are that Randy did it. If Randy had done it a day before, it's still ancillary to covered work, which is covered work in and of itself. And if you want to take the issue about cutting the ceiling open out of this completely, you still find for Mr. Fields under both 240 and 241-6. That's joblon, that's alteration. He was cutting insulation off of an interior, like an inside the ceiling HVAC pipe. If in joblon, the chiseling of a small hole to run a single cable to power an electric clock is alteration, cutting the insulation off an HVAC pipe to find a leak to ultimately repair it is also covered alteration work. So Mr. Parisi is arguing mostly having to do with whether it's a repair versus routine maintenance. Alteration is a separate ground upon which you can find this as covered work. And so I think that would answer the question.
The bottom line here, we have an unsecured ladder. Plaintiff said, you know what, the ladder gave way, I fell backwards.
Exactly, and Mr. Bishop was standing there and saw it happen. This is a very clear 240 case. I would talk about the 241-6 claim, but I think it's academic because I think that the 240 claim is so clear. And unless the panel has any questions for me, I will sit down.
I have one question.
Oh, sure.
The plaintiff is described as the maintenance supervisor. Does that have any bearing on whether we determine that this is that he did work that was covered by the labor law?
I don't think so at all because his title is not really the issue. I mean, they call it a maintenance supervisor, but for example, you could look at Caracolo against 800 2nd Avenue condominium. That's 294 AD 2nd 200. It's from this court from 2002. It's a building engineer who, an engineer is not a construction worker by title, but he was sent up to the roof of his building to investigate an alarm that went off from a water tank. He found the water tank was a little too full, and the solution was just to go down to the basement and open up the pumps and drain the tank a little bit. And he fell off of a fixed ladder while coming down from the inspection. He was about to go do the repair. That's a repair. If that qualifies as repair work, so does Mr. Fields' work.
All right, any other questions?
Thank you, Your Honors.
Thank you. So why don't we start off with my colleague's question? Do you want to repeat the question?
Please repeat the question.
Okay, go ahead.
Okay, so it's our position that this was routine maintenance, that the plaintiff was asked to check a leak. He may have done the work 2 days prior. If he was cutting, if he was doing all the work in that moment, as they try to argue, then maybe perhaps it may rise to that. Here we have an issue of fact that the work may have happened 2 days prior to the actual
What is
accident.
the issue of fact? That Bishop said it could have happened 2 days prior, but I'm gonna
Yes.
also admit it could have happened earlier today. His speculation is the issue of fact?
Absolutely, because in this case, there's no construction work, there's no actual alteration, there's no demolition work, there's no renovation.
So making a hole is not an alteration.
Well, it would depend under the case law. In this circumstance, he is the maintenance supervisor. He's looking for a leak. The hole was made 2 days prior. Now, the testimony of Wesley Bishop is that the plaintiff went up on the date of the accident only to check the leak and to put a bucket up there. So his testimony unequivocally is that the plaintiff,
Yeah, but they also intended to find the leak so that they could fix it.
yes, but
And Bishop testified that plaintiff used a very old 6-foot 8-frame ladder which did not have shoes or feet.
well, the problem, this is a multi-layered analysis. In order for the labor law to apply, there has to be a construction project, an alteration project, something like that. In this instance, there may have been hole cutting, but it would have been prior, and we're not even sure that the plaintiff cut the hole. On the date of the accident.
So you're saying that the only way that we can have, there has to be some kind of temporal proximity, closeness? What would that be?
Absolutely. What I'm proposing in my argument is
Immediate, the contemporaneous time?
contemporaneous would help. There's a number of factors. If let's say he worked for the repair company, that would help. He's very, very proximate.
Well, we know that that's not necessary, as my colleague pointed
it's
out,
not.
when it's the work that's being done.
It's the work that's being done, but here, I mean, every inspection done in furtherance of a repair is not automatically covered under the labor law, and that's addressed in the Martinez case. And I can give you the site for
I
Martinez.
know the site to the Martinez case, thank you.
Okay, so the Martinez case shows that there's different phases of inspection and work, and very importantly, in Martinez, they accept the fact that Mr. Martinez was not working for the asbestos company. He was doing a inspection in furtherance of this repair of the.
That's a little different, because Martinez involved investigatory work. That's not what we have here.
We do, Your Honor. It is investigatory work because he was asked to find the location of the leak, and what his testimony is that he cuts.
But in order to find the location of the leak, he had to cut through some things?
That's what his testimony is.
And then we have the testimony of Bishop.
We have the testimony of Bishop, which says the cutting happened 2 days prior to the accident.
No, he
That's
doesn't
not
say
what
that.
he says.
He's not sure.
He
doesn't know.
says, I think it was 2 days after, but I admit it could have been today by the
I'll
plaintiff.
tell you what, this is what we're going to do. You can respond to that, and then we're moving on. You can, this will be your last point. then
That
we're moving
creates
on.
an issue of fact, naturally and organically, because the accident did not occur at the date the work was being done, and he was not actually doing the repair. He was only putting a bucket up there, and Bishop testified that this was wear and tear work, that these incidents do happen. He says it's wear and tear. It's in the testimony of the non-party witness.
Thank you.
Thank you, Your Honors.
Reader versus Shulman Properties.
Good afternoon, Your Honors.
Good
Brian Isaac.
afternoon.
I represent the plaintiff, appellant, cross-respondent. This is an interesting statutory regulatory case post-club check. As you know, our position is that under 1 RCNY 15-10R2, there is an affirmative requirement that the fire escape at issue be actually guarded with a specific type of guard. And this is what it says. A round iron guard rail 3/4 inch in diameter shall be provided around all hatchways on all new balconies. This isn't a new balcony. And also, when necessary, around hatchways on existing balconies. This is an existing balcony. I wanted to be sure I understood my adversary's position, so I think I do. If you look at page 19 of my adversary's brief, this is what my adversary says should be done, and I'm quoting. Bearing this in mind, the only sensible meaning of the term existing balconies is balconies in existence at the regulations promulgation, this is in existence, but erected after 4/8/29. I just don't think that that says that. And I think if you look at your decision in the Klubczak case, it is different, okay? Because it deals with changes in the multiple dwelling law as opposed to a regulation. But this is what you said, and I'm quoting. Moreover, section 53.9 would be superfluous if it only applied to fire escapes post-dating 1929, because those fire escapes were already governed by section 53. That, I think, is my adversary's claim. I don't think it makes any sense to me. Now, I could be wrong, I could be not looking at it analytically, but to me, it's just not correct. Now, to be fair, my adversary says, wait a second, Mr. Isaac, you're forgetting some stuff. And this is what my adversary says, I forgot. 1510A in intent says, quote, these rules have been approved by the department to supplement the provisions of section 53 of the multiple dwelling law in relation to fire escapes. Well, supplement doesn't mean constrict. If you look in a dictionary, it means adding to. So I don't think that this hurts me. The next argument that my adversary makes is, well, you forgot 1510D. This is what 1510D says. Except as provided in section 15-10C, in any existing multiple dwelling, any existing means of egress which was fully permitted prior to the time of the multiple dwelling became effective may be continued as a legal means of egress as hereafter enumerated.
Counsel, I approach this from a different place, and I'm curious what your reaction to this is. It seems to me that where the regulation provides that the guardrail shall be provided on all new balconies and also when necessary around hatchways on existing balconies, it seems to me that that raises a question about when something is necessary and that that's not definitively decided, definitively established in your motion. So I don't understand why the lower court wasn't right in saying, there's a question of fact about what the statute means, what the regulation means by when necessary.
Let me address that directly.
Please.
If the expert had said, okay, this is Mr. Rattari. Now, I know how well you read these affidavits. He didn't write short affidavits, 250 pages. If he had said, this design was reasonably safe without a guard, I'm not here. He never said that. He was very careful about what he said. Let me tell you what he said verbatim. This is at 1199 to 1200. Rattari said that the opening was, quote, properly maintained that the defendants, quote, properly maintained the premises and kept the subject fire escape in proper and serviceable condition. Yes, it was in a proper and serviceable condition for a fire emergency, but not for someone standing there. And then he goes on to say that the fire escape, quote, affords a reasonable degree of safety to all those who use it during a fire and exercise a reasonable amount of caution while doing so. This wasn't a fire.
You know, but just seems to me, just to follow up on my colleague, neither your client or the other side really presented proof to show either that the supplementary regulations apply or they don't apply.
A question that I have,
Sure.
and I think it encompasses both Justice Gesmer's and Justice Kennedy's question. Who determines when the guard is reasonably necessary? And prior to an owner having a guard installed in accordance with the regulation, does that owner have to be told you need to have a guard installed? When the fire escape was built prior to the regulation?
I saw my time was up. Could I just answer that
answer
question?
that.
I'm just kidding.
No, fine.
So the answer is that was actually covered in Klubczak. And the answer is, and I'll read it to you. You said it better than I did. Defendants contend that removal of the fire escape was not required under section 53.9 because agency permission was a prerequisite to removal. However, the requirement to obtain permission prior to removal of a vertical ladder fire escape does not mean that the removal requirement was nullified, only that the Department of Buildings should be made aware of the renovation in order to monitor the construction and replacement of the fire escape system. Can I just have 15 seconds and I'll sit down? Justice Kennedy and Justice Gesmer, I understand where you're coming from.
Yeah.
Just one thing. My expert said that this was unsafe. The Atari, from what I'm looking at, never dealt with it. So under summary judgment principles, that's where my proof comes in. But if you disagree with me, which you very may well do, I would only ask that, as per Club Check, you would say that these regulations are facially applicable, because that's what the Club Check court said as well. Thanks for listening to me.
Thank you.
Good afternoon, Your Honors. Karis Lund of Kahana and Feld for Respondents Appellant Schulman Properties International LLC and Brownstone Professional Services Corp. I'd like to address first plaintiff's argument about 1 RCNY 1510. We believe we don't even get there because of the New York Administrative Code. This building was grandfathered into compliance.
But that doesn't determine whether or not it had to have a railing around the fire escape if, as the regulation says, it was necessary. So if it was necessary, then it loses its grandfathering status.
Well, so...
And I agree with my colleague that the question is who determines when it was necessary, but if it was necessary and they didn't do it, isn't that a violation of the regulation?
So if you actually look at the regulation, you look at 1510A, I believe, the regulation itself actually says that the DOB is responsible for determining when a regulation is determining instructions and
But if there's nothing in the record that suggests the DOB ever looked at or didn't look at this.
Right.
So if they didn't determine it, but now the experts say it is necessary, doesn't that say that it comes within it?
well, the experts can't do statutory interpretation here.
I understand that. That's a problem. That may be a problem with the way the regulation's written, but we still have to deal with the fact that it says that they ought to have a railing if it's quote unquote necessary.
Well, so I want to take it back a little bit. The New York Administrative Code, actually, so this is the 1968 code, right? And it grandfathers into compliance MDL 53, 232, and 1 RCNY 1510 R2. And the two exceptions, right? There's two exceptions. If there's 60% or more alterations in the building, then the entire building has to comply. Or if it's 30 to 60%, then that portion. And so,
Well, but there's also an exception if it's necessary.
well, that's a separate thing. That's not in the administrative code.
Would it be applicable then if there was a new fire escape installed?
If there was a new fire escape installed, it would be. And I assume you're talking about that transaction report.
Well,
Right.
there's no other.
Yeah, so, right, so that 2010 transaction report, it says installed new fire escape. And it says for $1,200, and we all live in New York.
Well, it doesn't really say for $1,200. It says that they paid $1,200, but there was a balance of $48,000. So we don't know how much was paid. We know how much is owed, right? And we know that there was a payment of $1,200. So we don't know what the total price was.
Sure, that's not how I understood it, but I see what you mean. But in that case, though, we have testimony from the Brownstone assistant building manager who said that the fire escape was not replaced, that it was merely inspected and repainted.
But that conflicts with the information my colleague just said, so.
Issue of fact.
Well, I understood it to say that it was $1,200, and I think plaintiff actually does too, because plaintiff says, well, maybe it's missing a bunch of zeros. If they didn't,
That is a question of fact. Maybe we don't know.
well, so their position, right, was that okay? We brought this transaction report up. It says $1,200, and
And
you're
says
reading
new
it now
fire
different.
escape, too.
Yes, it does, right. But then we brought forward both the building manager and then also the Brownstone principal, Sion Misrahi, confirmed that there was no new fire escape installed and that all permitting requests went through him. So if there had been a permitting request for a new fire escape, because he has to give that to the DOB, then he would know if a new fire escape had been built.
So
And
we should just ignore the building transaction detail.
no, not at all.
Who prepared that build-in transaction detail? How'd that come about?
I assume the building manager built it or made it, but I will also say that both experts.
Isn't assuming something we don't usually do on summary judgment?
fair enough. I will say both experts, though,
How
also,
would the expert know? Why isn't that speculative?
well, because they inspected, they went to the property, they inspected it, and they determined, Mr. Atari determined that it was original to the building. There was also a placard that said 1907 on the fire escape. He's an engineer, that he determines these sorts of things, and Mr. Silberman didn't disagree with that. He didn't dispute that the fire escape was original
How
to the
would they
building.
even in a position to opine on that when we, and particularly when we have this transaction? I mean, the transaction report really is the thing that creates this issue of fact, and it's your transaction report.
Well, again, I understood it to say $1,200, that had been paid, $1,200, and that
You have
$1,200.
5 other people saying maybe not, right? Issue of fact.
I mean, I would disagree, especially given that our experts and the testimony from both the building manager and the principal also said that. And I see my time is up, so I'll save it for rebuttal. Thank you.
Your Honor, the transaction report is on 1871, and it does show a balance from what I can see. It's kind of hard to see, but
48,000 and change.
48,168.88, yeah, it's right there. My adversary brought up a point that Justice Gesmer and Justice Kennedy, I should have brought up before, I'm sorry, I just ran out of time. If you look at 1510A, second paragraph, it says, "The voluntary erection of fire escapes on private residence buildings or business and residence buildings shall be in conformity with these rules and regulations unless otherwise directed by the borough superintendent of the building." That's what you got into. And then the next sentence, it is the intent of these rules to cover only general conditions, and they are not designed to cover specific or special cases. Here's the sentence I want you to focus on. "When such may occur, the owner is required to consult the Department of Buildings and receives instructions before starting work." That's what Mr. Silberman did. I know you've read the record, so I don't have to say it, but he actually put a request into the Department of Buildings and said, "Does this require a railing?" He didn't talk about the building, but he gave a picture, and he got back a response. I'm not saying it's determinative, but it's certainly not prohibited, and it seems to be encouraged under the building code, and I'm assuming, I'm a construction idiot, I don't even have a power tool, but the reason is you don't want to do work and then have to undo it. So my position is that we do have enough here on the issue of necessity to shift the burden, and my position is that the Atari affidavits did not. 15 more seconds and I'll sit down. I don't think that you can establish that the plaintiff was comparatively negligent as a matter of law. That's on the second issue of her appeal. They're not joyriding. They were in an apartment. They heard screaming. They went to see what was going on. They
Why
did
does she have to step out onto the fire escape?
Yeah.
Well, look, I'm not saying that they don't have a defense, but it's also they wanted to see what was going on. I'm not sure that that's
Stick your head out the window?
Yeah.
good, but they said I think they said also they wanted to get a better view. And
Well, they
everybody-
got a better view.
She got a good view.
Oh, she sure did. Yep. So I don't think that's a question to be decided as a matter of law. Thanks.
Thank you.
My colleague here said that the DOB email, he references that Mr. Silberman emailed the DOB and got a response. That DOB email is inadmissible hearsay, right? If there was an expert in court and we provided this and there was no name, we don't know who it's from, and that just wouldn't be admissible, and it shouldn't be here. And not only that, there's literally a disclaimer in that email, which Mr. Silberman conveniently extricated from his recitation of that email, that says that it's only for general conditions and that it's not to be construed for specific buildings, kind of similar to that provision that my colleague just read. And beyond that, it's also, he says, oh, well, the professional reliability exception applies here, but it really doesn't, because we've shown that it's not reliable. And he says, well, engineers rely on this information all the time, but he hasn't shown that engineers rely on emails from, we don't know from
Well,
who.
if they want to know whether or not a guardrail is necessary, who would they contact other than the DOB?
Right, but you would assume that if the DOB actually thought that we were in violation of that code, that they would send someone out. No, the building was never cited for a
That's a big
violation.
assumption about the Department of Buildings.
Well, I mean,
They
you would.
I mean, that if they thought there was, that if someone, if they had some idea there might be a problem somewhere in the city, that they would act on their own to send someone out?
Well,
I don't think we can make a decision with that assumption.
We would also argue, though, besides the fact, right, that this email is from someone who we don't know who it's from, and the email was given as a response to Mr. Silberman, who he provided actually some of the wrong information. He said the building was built in 1905, so already the reliability of that email is put into question. But there was no interpretation in that of when necessary. It doesn't say, okay, well, when necessary means this. It just cited to 1 RCNY 1510 R2, and then it just provided a link that now doesn't work. So there was no interpretation at all.
You're saying that there's issues of fact left and right.
Thank you.
Thank you. Gray versus Nassau Life Insurance.
May it please the court, Evan W. Gray, plaintiff appellant.
The mic. Great,
May it
thank
please
you.
the court, Evan W. Gray, plaintiff appellant, trustee, pro se. Plaintiff is the successor trustee of a trust entered into in 1985 for the primary purpose of being the beneficiary under life insurance policies, insuring the life of Chester L. Gray Jr., and one of those life insurance policies was issued by Phoenix Mutual Life Insurance Company, which is the predecessor in interest of the defendant, Nassau Life Insurance Company. I'm going to go right to the grounds upon which the Supreme Court erroneously dismissed plaintiff's amended complaint. The first ground was under CPLR 3211A4, which only authorizes the stay or dismissal of an action in Supreme Court when, quote, there is another action pending between the same parties for the same cause of action in a court of any state or the United States, end quote. In its motion for the supposed other prior pending action, Nassau relied exclusively upon an amended complaint filed on June 13, 2023 by Evan W. Gray in his individual capacity as a beneficiary of a 1996 trust, which is a different
We
trust.
can get right to it.
Sure.
Now, the 2023 federal action, that's about the 1996 trust. You know, the funds the plaintiff was seeking in that action was really the, what, approximately the $165,000 in death benefits, right? That Phoenix and Penn Mutual should have paid to the 1985 trust.
No, that's not what the money that's seeking. That's seeking money that was removed from the Merrill Lynch, New Hampshire brokerage account of the 1996 trust and was put in escrow.
Right. But
That's what
what's the amount though? 165, right? That it's the same amount, right?
It's the same amount, and the reason it's the same amount is because the trustee of the 1996 trust was trying to give himself personal benefits as executor of the trust in case he got
So it's fair to say the 2023 federal case, the Supreme Court case, right, that what's really being sought is that the benefits, well, let me say it this way, that to place the benefits in the trust on behalf of the beneficiaries of the 1985 trust, right?
No,
No? Okay, tell me.
no, I'm sorry, you're talking about the federal action?
Yes.
The federal action is to get money that was removed from the 1996 trust back into the 1990.
But it's the same, it's the same fund, it's the same monies, right?
No, it's not the same monies.
Okay, tell
It's
me.
monies that was removed from the 1996 trust. The 1996 trust never had
But
any
isn't
connection
it
with
all
any of
based from the payout from the life insurance?
I'm sorry?
It's all based upon the payout from the life insurance, right? the payout from the life insurance from Phoenix went to the 1996 trust when it should have went to the
No, it did not
1985
go to the
trust?
1996 trust.
It went to,
It went to the former executor of the estate, which was in Massachusetts, and deposited into a Massachusetts account. They're totally different funds. It's double the amount of funds. There was one.
where did the funds come from? The funds, wherever the funds wound up, where did they originate?
No, there were. Phoenix paid about $107,000 to the former executor of the estate of Chester L. Gray Jr. in
They originated
Massachusetts,
from Phoenix.
deposited
They
in
originated from Phoenix.
Right.
Okay.
Without authority under the policy. They then separately, the trustee of the 1996 trust took $165,000, which is more than the Phoenix payment, and put it into escrow, removing it from the 1996 trust, and therefore depriving the beneficiaries of the 1996 trust of both the money and the income from the money since October 2018, which is a lot of income on that money. So the money in New Hampshire that's at issue is only money from the New Hampshire brokerage account of the 1996 trust. The money that was paid to the former executor was dissipated. It was used to pay estate expenses.
All right, thank you.
Good afternoon, Your Honor. Mark Berman from Bond, Shenick and King, representing the respondent Nassau Life. Justice Waterman got it exactly right. She dismissed the action under 3211A4 for prior action pending and for lack of a necessary party. She held the New Hampshire actions, and when I say New Hampshire actions, that's the probate and the federal actions.
But we're really only talking about the 2023 federal action at this point, right?
What we're talking about, no, we're talking about the federal action and we're talking about the probate actions, Your Honor, because, counsel started off with, well, we moved specifically on the amended complaint and the federal action. Reading the record, counsel didn't disclose in the heat of the argument before Justice Waterman says, aha, oh, there's these probate decisions. If you look, and those two probate decisions we didn't have, Justice Waterman ordered them to be produced. Those probate decisions are prior to this state court action. And Your Honors, if you look at those probate actions, that's dated 2021, Your Honor, and 2022, and I refer you to our record page 335 in the 2021 probate action, it specifically addresses the Phoenix life insurance policies. There's only one pot.
Counsel, so in both actions, plaintiff alleges that Phoenix paid the proceeds to the wrong party, correct?
That is correct. So it's the same pot, it's just they say it happened to go to the estate, and now he wants that same amount to go to him. But what makes it, what is dispositive here, he admits that he is a beneficiary of the estate. Okay, so counsel, pro se counsel wants it both ways. It's the same $110,000, Your Honor, okay? The probate actions both dealt with the Nassau payment. The probate actions basically say there's a surcharge, a constructive trust, and guess what? He's a beneficiary. So this is trying to recover the same amount of money twice.
That's what I
That
was
is
getting
correct. And then, I mean, it is pretty straightforward. It's not convoluted. The facts are quite clear.
And presumably, if it were to consolidate, if the dismissal remains in place, and the only thing left for the proceedings in New Hampshire, and it was all before the same judge, there wouldn't be a double payment.
That is correct. And the fact of the matter is that money, this Nassau money, was the object, one of the objects of that. and they said there was a surcharge, so the money goes back to the estate. Counsel here is a beneficiary of the state. If this case were to proceed here and plaintiff was successful, my client will have paid it twice. And then, guess what? In New York, and Justice Waterman was correct, the estate is not here, the brother is not here, so now we've paid twice, and we have no right to recover it.
So it would be inequitable.
It's pure prejudice, because we'd be paying it twice. It's undisputed that we paid it once. You paid it once. It's his fight, and Justice Waterman got it right, said he was strategic. He filed it in a certain way. He could get this money if he wanted to in New Hampshire. But now we have a Penn action, Phoenix action, a multiple probate action.
He's suing different defendants for the same property, basically, the Phoenix death benefits.
Thank you very much, Your Honor.
Your Honor, it's simply not true.
Okay, let me hear you.
The money that's at issue in New Hampshire is totally separate money from what they paid. They paid the estate in Massachusetts. The money in New Hampshire is money that was taken out of a New Hampshire account, which only goes to the 1996 trustees. The 1985 trustee is the beneficiary under the life insurance policy. There was no, under CPLR 3211A4, there has to be a common defendant and a common plaintiff. In this case, there's neither a common defendant or a common plaintiff.
Do you think that Mr. Gray or the estate should be necessary parties in this litigation?
No, the estate can't be a party because the estate is only responsible for debts of the decedent before his death. The former executor could be named a party if the respondent wanted him, but there's no, the plaintiff trustee does not have any claim against the former executor.
But if they now, let's say that they pay you, and monies that they have already paid out, who do they collect from? That first amount that they dispersed?
From my perspective, that's up to them.
It's up
for
to them
to pursue whatever their claims are.
Would there be a double payout, though? Would there be a double payout? Is there one? Is there a danger of that?
There's a danger of a double payment, but there's no danger of a double recovery. Because
Sorry, what's the difference?
the difference is that they paid, without authorization under the policy, the former executor. And that money was used to pay estate debts, mostly the attorney for the former executor. Here, I'm looking to get the money that the named beneficiary under the policy is entitled to. The fact that they paid someone without authority under the policy does not prevent the designated beneficiary under the policy from having a right to obtain the payment.
Thank you.
Thank you, Your Honor.
Scott and Scott versus Kaplan, LLP. Good afternoon.
Good afternoon, Your Honors. My name is James Sharon. I represent the appellants Scott and Scott. We're here on a dismissal of the underlying case. It's the position of the appellant that the court erred. The court relied upon extrinsic evidence that did not flatly contradict or utterly refute the allegations of the complaint. This is a 5-bullet point email. 4 of the paragraphs are acutely relevant. This is the court below construed. I would suggest, Your Honors, when you read that email, you will see in paragraph 1, there was an obligation or a agreement to pay $6 million in a...
Is that agreement ambiguous in your...
Your Honors, I didn't think that when I filed this case, and I actually don't think that now, because I believe the final settlement is the settlement, is what final means, the last settlement.
Did it make reference to a final settlement pursuant to any particular order or pending order on appeal?
It did not, Your Honor, and
And it could have.
it could have, and let me address both your questions. So the way the court below dealt with that is to say, use the word article, the final settlement, as opposed to a final settlement, attributing to the plaintiffs the argument that we were arguing any federal settlement. But you're absolutely correct. The settlement at issue at the time of the agreement was the 2012 settlement. The agreement, the email, does not refer to that. It does not refer to it at all. And moreover, what it does say is this case is contingent upon successfully concluding after the current appeals, meaning a future event has to happen. The case has to successfully conclude because remember, context is everything here. At the time of this email agreement, the appeal that was pending was deciding whether the two classes, the injunction class and the money class, could be prosecuted by the same counsel. But the fee that had already been determined by the trial court, $540 million, was not at issue.
So there was no scenario in which the settlement would be vacated as to the fee amount? Or was it done? I mean, I guess my question is there a scenario in which the appeal court could have vacated the settlement and it then proceeded to trial? What does that mean then for final settlement?
I'm not sure I understand your question, Your Honor, but let me give it a shot, if I may. So our position is the final settlement is what the word implies, final, the last event to happen. And if you look at footnote 5, that's referenced in our brief, in the actual settlement agreement at issue in 2012, the money is being escrowed and doesn't get released until all other appeals, all other events are exhausted. And that's consistent with what the email says, is the money does not get paid until it is distributed.
So it's really your contention that, paragraph 3, that it's forward-looking and it's linking performance to the successful conclusion of the, litigation, the approval of the litigation and the fee award.
Correct, because at the time, there was going to be more litigation. That's why we say after current appeals. There is something else that's going to be happening. Yes, ma'am.
I find two things odd about this agreement. One is, if the agreement meant what your adversary thinks it says, then it surprises me that paragraph 4 wouldn't say, our case shall have no fee obligation in the event that the 2012 settlement or fee award is overturned.
Exactly, Your Honor. That's somehow the word final got lost and final got substituted for 2012, but that's not what this email agreement says.
The other thing that's confusing about this is that if a final settlement is overturned on appeal, that doesn't preclude the party. I don't know what that means, because if any settlement got overturned on appeal, it's likely that the parties would try again. So it seems to me that it's almost an oxymoron, because if it's final and got overturned, then why wouldn't they try again? It seems to me the critical issue is, as Justice Kennedy said, whether fees are getting dispersed.
I agree with that, Your Honor. That is what paragraphs 2 and 4 say. May I finish, Your Honor?
Please.
But to be clear, the final settlement, what could have happened in this case is the settlements get vacated and it gets tried. And whatever happens at that trial, it happens. That's not what they were doing. Remember, my client paid $6 million on the promise for something. That was not an illusory promise. I apologize for going over my time.
It's okay. It's okay.
Your Honors, my name is William Kolb, attorney for the respondent, and I'd like to introduce Mr. Martyr, who's been admitted pro hoc vice, and with your permission, Mr. David Martyr is ready to proceed.
Welcome.
May it please the court, as Mr. Kolb mentioned, my name is David Martyr. We represent the respondents here today.
So tell me, why would it be unreasonable to, interpret final as, the settlement that ends everything rather than something that's interim, still subject to appellate review?
There are two reasons, Your Honor. When you're looking at whether something is ambiguous or not, you have to look at the context of the agreement, and you have to look at the other surrounding language. Let's start with the context of the agreement. What's being ignored here is that this was a class action. And under class action procedure, you have a preliminary, once you have a settlement, you have to get preliminary approval. Then notice goes out to the class, then it comes back to the judge about 9 months later, and you get final approval, and then it becomes a final settlement. So the term final here doesn't mean the last in a series. The term final here refers to the fact that the court had finally approved the settlement. And when it says the final settlement, it's referring to the one which had been approved in this case just before the agreement.
So if that was what you meant, given that there are excellent attorneys who made this underlying casual agreement, why wouldn't you have said, what you were referring to was the settlement reached in 2012, why didn't you say the 2012 settlement?
Because you're
it was on appeal, so you knew there was a possibility it would be reversed, and presumably you would have tried again to try to settle it. So if what you were referring to was that one, why didn't you say that?
Because, Your Honor, at the time, there was one final settlement. You have to look
But
at...
it wasn't final, because it was on appeal, so clearly it wasn't final.
No, it was under Rule 23, Your Honor. The court had issued an order finally approving of the settlement. That made
But
it
it
a final
also says, being permitted, that this applies successfully concluding after the current appeals and award of attorney's fees. And so at that point, there was no award of attorney's fees when it was sent back for settlement, when it was reversed, right? So it wasn't final.
It was final, Your Honor, under Rule 23. There had been preliminary approval.
You didn't say under Rule 23 either.
But that was the
That
context.
might have made it more clear, but your choice not to make it more clear and to have a email agreement on that millions of dollars turned on seems to me leads to a possibility of ambiguity.
Your Honor, I would agree possibly if it wasn't for the other language in the agreement. But the other thing we need to look at...
Which language makes it unequivocal? I can't see it.
I can explain it to you, Your Honor.
I'm curious.
There are at least 3 reasons why the interpretation that Scott and Scott's counsel has urged is literally impossible. The first one is, Your Honor, paragraph 4 says that there'll be no fee obligation owing if the award and the final settlement is modified on appeal.
It says
under their
It's
interpretation...
overturned or modified on appeal. Was what your adversary, maybe I misunderstood him, said that part was not. Was it?
It was. The final settlement that was at issue was, in fact, went up on appeal, and the whole settlement was vacated. We had to go back down and redo the whole settlement.
But that's the question, is what final settlement means. And it's not unambiguous because obviously let's...
And also, why include concluding after the current appeals? What were you saying by that? What were you agreeing to there?
That's the second provision. There are 2 separate provisions that make this impossible. One is paragraph 4, which says it can't be modified on appeal. If the correct interpretation were the ones that they are urging, then it could never be modified on appeal because they're saying it's the final settlement that resulted in the monies being paid out. That could never be modified on appeal. So paragraph 4 would make absolutely no sense.
So they, by the time they've paid $6 million, right?
Yes.
And on the hope chance that they might get money back or that they intend to get money back once it's settled?
They will get money back if the current appeal settled, but all bets would be off.
But if the current appeal didn't settle, they get nothing?
Yes, because at that point, all bets would be off because the case would go back down. All the summary judgment motions that were pending before the court would come back to the fore, and we could have 10 years of litigation ahead of us, so it wouldn't be fair.
So they paid out knowing that the possibility that they'd never get anything, even if it settled at another time other than this current time. Does that? I mean,
exactly. Remember, the $6 million wasn't given to them out of the goodness of their heart. There was a dispute over whether they were entitled to that $6 million. And the resolution of that dispute was that we'd make them whole on that if we won the current appeal. And as I said, we know that that has to be the language because if you look at paragraph 2, it mentions the current appeals. If it didn't have to do with the current appeal, they never would have used that language. The word current appeals wouldn't even belong in paragraph 3.
Thank you, counsel.
Thank you.
Counsel, is there a guarantee that after the settlement, I'm not going to call it final, the settlement was overturned on appeal, that the same firms would be representing the class?
Well, Robbins Kaplan was reappointed as.
Yes, but was there any guarantee that that would happen?
No, they had to apply, and the court approved class counsel. And I think that was 2016, Your Honor.
So that language, along with the language after the current appeal, would that in a way make it final and binding, that settlement that they reached, would that make it final and binding at the time that this little email goes out?
This is important, Your Honor. Remember that in this agreement, it was not based on a percentage. Scott & Scott was not getting a percentage of whatever that fee might be in the future. It was getting enough money to get it to $20 million. That was the quid pro quo. And the first paragraph says, if we don't get it from here, Robbins Kaplan goes out of pocket to pay it. Paid $6 million over here in this case, and we're going to get up to whatever it takes us to get to $20 million in the interchange fee case. That was the deal. And so when you take, to your point, Your Honor, when you take the possibility of what might happen to the fee and who might be lead counsel at that point, doesn't matter. The deal was between Robbins Kaplan and Scott & Scott. And it was to reach parity in terms of who was going to get paid out of what bucket of money.
So their argument now is, since that settlement was overturned back then, all bets are off. That's their argument, in essence. We don't have to pay the $20 million anymore.
Yes, Your Honor. They substitute the word 2000. I'm sorry, Your Honor. They substitute the word 2012 settlement agreement for the final settlement. That's how they establish their argument.
Thank you.
Thank you, Your Honor.
Anonymous v. Anonymous?
Good afternoon, Your Honors.
Nope.
Richard,
We have to wait.
oh, sorry.
No, no.
You got more?
Richard Emery and Maggie Turner for the appellants. This court has, on multiple occasions, and in fact, the members of this bench, as we researched it, have on multiple occasions rigorously policed the issue of civil contempt in any number of different contexts. Justice Gesmer had 7 cases in the last few years, 6 of which he did not uphold civil contempt. Justice Pitt Burke was 1 and 1 and 2 in 2 different cases.
Thank you for giving us our stats. Why don't we talk about this particular
Well,
case
I understand.
and see why it wasn't providently exercised by the court?
Yes. The standard that this court has rigorously enforced is one in which a clear and unequivocal mandate is violated, and the burden of proof.
Which Justice Marshall found there was here, and why isn't there a clear and unequivocal mandate in this case requiring your client to pay all of the children's educational expenses? I don't see any lack of clarity in his obligation. So perhaps you could show me where it is.
Okay. What is required in the context of civil contempt
As you pointed out, I know that.
is in fact, not only is it has to be in the context of money paid, it has to be the amount of money as well as a date certain. Neither of those things were specified in either of the court activities which underlay this contempt. The first one by Justice O'Neill Levy said, based upon the information before this court at this time, plaintiff is obligated to pay the educational costs incurred under the settlement agreement, subject to reevaluation by the Taiwanese court upon the conclusion of the child support proceeding. Nothing about the amount of money, nothing about the date of payment. Both things are absolutely required under this court's jurisprudence. The second basis on which they sought to have civil contempt was the Justice James directive at a
But that wasn't a new obligation, counsel. You know, really, it referred to the June 2023 order that was already in effect for 6 months. So it was, saying you have to go forward with the order that's already been issued. So it wasn't a new order.
No one contests that the husband, my client, had the obligation to pay 100% of the educational fees. The issue is, what were they fraudulent? Were the invoices that were presented in any way, shape, or form reliable in any way? There was a request for reimbursement, but no one ever demonstrated that the person who was seeking reimbursement, the wife, had made any payment. The school in which the kids were supposedly being educated was something that she had concocted herself with her cousin.
Why is that an issue under this order?
It's an issue because the invoices were fraudulent. It's an issue because
How have you shown that they are fraudulent?
the record is replete with allegations, and there's no proof.
Allegations.
Any documentation to show?
There was an attempt, multiple attempts to get a hearing to make a finding on what was not fraudulent. And more importantly, as you know, civil contempt is an equitable remedy. Once Justice James said on a date certain an amount should be paid, my client put in escrow a very disputed amount, but the greatest amount that was claimed was put in escrow. And it sat there, and this is very important. It sat there for a year.
Let's go back. Let's go back. Because Justice James said, comply with the June 23 order. And I'm going to paraphrase. She said, pay, right?
Right.
So what do we have here? So supposedly, if you don't know what's going on, then why do we have that letter acknowledging the sum that was supposed to be paid, $288,368.52, and placed it in an escrow account rather than pay?
Because that amount was hotly contested. We were seeking a hearing over that amount because it was a fraudulent amount.
What effect
but we put
does,
it in escrow anyway.
What effect does the Taipei courts, the Taipei Department of Education's approval, what effect does that have on your argument?
Very little, because we concede that the children were in this school, but the school was one in which there was no reimbursement shown to the wife who supposedly paid. There was no hearing. There was no factual finding that the wife paid.
Did the school
That's why the amount was put in escrow rather
But the
than
parties'
paid.
agreement expressly provided that invoices would be acceptable, that would constitute appropriate proof.
Yes.
Those invoices were fraudulent. Those invoices.
How? How were they fraudulent, counsel?
No, let's be clear. The invoices were for dates prior to the settlement agreement. So by definition, the number 288,000 was wrong on its face.
There's nothing in the settlement agreement that limits your client's obligation to payments to invoices after the settlement agreement. Is there?
After the settlement agreement, there is an obligation to pay if they're submitted 60 days, which they were not, in advance of the payment.
It didn't preclude that your client was also obligated to make payments for invoices incurred before that date, right?
No, it was a forward-looking settlement. But I have to emphasize one quick thing.
On rebuttal, that's when you can do it. Thank you.
Good afternoon, Your Honors. My name is Joseph DeSimone. I represent the respondent. May it please the court. This is simply a case of somebody who doesn't want to comply with court orders. It took 3 motions to gain Mr. Wang's compliance with this order. He was told not once.
Is a hearing required with such allegations as the school that the children are in has something to do with the mother and she's not actually paying, so therefore to reimburse it? Should a hearing just resolve all of that? Why isn't a hearing necessary?
Well, I'll tell you, Your Honor. The hearing about whether or not this is a proper school for the children is a custodial issue. The lower court already ruled that there is no jurisdiction regarding custodial issues, and the Taiwanese court took up that issue and issued an order saying that my client had the sole discretion to choose and administer the children's education.
But what about the financial obligation? Because that's really what's at issue here, right? His 100% reimbursement. He's disputing the fact that this money's actually owed because maybe the kids are going to school for free. I'm paraphrasing, but that seems to be what the argument is.
Well, but he hasn't established that argument, Your Honor. As the panel pointed out, the agreement requires merely that invoices are presented. My client also put in an affidavit saying that the children are attending that school, and again, pointing to the Taiwanese court, if there was litigation there about what is happening in Taiwan, the assumption is that the children are going to school in Taiwan. And again, my client was given a court order from the court that had jurisdiction over the custodial issues to make the choices regarding.
Nowhere in the settlement, agreement did it indicate that, the educational costs had to be agreed upon or the father's consent was even required.
That's correct, Your Honor. And indeed, it said that the parties will continue the course of education that the children were already in. They were in this school at the time that the settlement agreement was executed.
Was there a requirement in the settlement agreement that your client first pay the tuition costs and then get reimbursed by the plaintiff?
There was a requirement that Mr. Wang was supposed to establish and pay the monies in advance, and he didn't do that, just like he didn't do a whole slew of other obligations under the agreement, because the motion that underlies the appeal dealt with four other obligations which he didn't do, and that's not.
And he said he wasn't paying the education because he didn't agree to the school.
That's right.
And that's nowhere in this agreement.
That's correct, Your Honor. There's nowhere in the agreement that says that he has to comply, that he has to.
All it says is that he's responsible for 100%
100%.
of
There's
the
another part in there that says that he has to agree on, he has to pay for only add-on expenses that he agrees for, but not with respect to the education. Yes, Your Honor.
Mr. Emery argued that it was improper to hold his client in contempt because neither the settlement nor Justice O'Neill-Levy's order specified a date when payment had to be made. What is your response to that?
Your Honor, that was the first order. Then he disobeyed that order. Then there was a second order. And the judge in that case, very gave of it, she was cognizant of that sort of clever little argument and said, you pay this money at 5 p.m., adding Eastern Standard Time because she knew that he was in Taiwan on a specific date. And instead of doing so, he took the money, conspired with his counsel, not the counsel sitting here, and put the money into an escrow account without any authority, without an order from the lower court or from the appellate division. He didn't seek a stay. So he and his counsel conspired to withhold those funds from my client, putting him into an escrow account that they had no authority to establish. And there was a very specific time and date that he had to make those payments. I don't know how much more specific. If they needed the exact second that the payment needed to be made, I'm not sure what they're talking about.
Did the first order
motion to get?
Did the first order have a firm date by which he needed to pay?
The first order is not the one he was held in contempt for. The first order said pay. The second order said pay on a specific date, 5 p.m. Eastern Standard Time. So you can't get more specific than that. And he cognizantly said, I'm not going to obey that order. I'm going to put it in my lawyer's bank account.
So he basically is in contempt of the second order, not of the first order.
That's correct, Your Honor. I believe that was the ruling. The first order, it took a second order to follow up on the first order. And then the third order is what found him in contempt for failing to abide the second order.
Thank you.
You're right. Thank you.
My colleague is just flat wrong. If you read the opinion, it's very clear that Justice James is holding him in contempt under the first order based on her subsequent directive, which she says herself is not in order, and with the time, but it does not have the amount of money. Posit this situation. What if they'd sent us invoices for $5 million for 3 years of education or 2 years of education? You're saying that because she says he has to pay, he has no remedy? What he did was very important here. What he did was he put the maximum amount into escrow, and it was there for 1 year and 3 months, and they did nothing about it, and the court did nothing about it. All they had to do was file an order to show cause and say, release the escrow to me. They did a gotcha here. They wanted the contempt motion for their own purposes in Taipei and in the custody disputes, which were collateral to this. They let it sit in escrow when they could have just gotten the court to release it if it was so clear.
I'm sorry, what are the purposes you're claiming that served them?
Oh, a civil contempt is extremely damaging to my client. The civil contempt damages him.
Maybe it's damaging to him, but how would it serve the interests of the
Him.
wife in getting paid for her?
Oh, it serves her interest in a much broader category of problems in this divorce. Custody issues,
That's none of
control.
that's in the record before us, right?
Yeah, it's all in the record before you, actually, but it's not the focus of this appeal. The focus of this appeal is the gotcha nature of the contempt citation here, which is based on Justice James never specifying an amount, which is absolutely in this court's
But you don't disagree that she set a date?
Excuse me? She
You don't
set a
dis-
date,
And
and
a
that's when
time.
he put it in escrow. He put it in escrow on that date.
And what authorized him to do that? What did he seek a motion to re-argue, to get permission to put it in escrow while it was being resolved?
At that-
I'm just curious, was there
Well-
any attempt? If that was what he thought was an appropriate remedy, would he have gone, did he go back to the
he
court and ask?
notif-
Excuse me.
Sorry, I'm sorry.
Did he go back to court and ask for permission to do that?
They went to court 3 weeks after it was, no, actually 6 weeks after
Before
it
he
was
put it in escrow, did he go back to court and get permission to do that?
That he did not do.
Thank
Did
you.
he go back to court and get clarification
He
as to how much money to put in?
They went back to court, and the judge recognized the escrow, never saying the amount again, but recognized the escrow as the biggest, largest amount claimed, and then it sat for another year without any action by either the judge or them to obtain it, which would have been the simplest thing in the world. This is an equitable remedy, civil contempt. And it's inequitable. It's totally unfair to let that money sit there, let them have access to it essentially by a simple order to show cause.
Why put it in escrow, counsel?
Why put it in escrow? Because he'd never get it back if he gave it to her. And he
Thank you,
wanted a hearing.
counsel.
He wanted a hearing.
Thank
on the
you.
Accuracy.
Thank you. Aveson Young, NY versus 459 West 50th Street.
Good afternoon. May it please the court, Amy Markel Scotto for defendant appellants 459 West 50th Street LLC and 182 Stanton LLC. The trial court improperly granted summary judgment where the portfolio agreement governed only the sale of all 4 buildings. The plaintiff respondent accepted 1% commission in accord and satisfaction. and
Did they not dispute that 1%? Did they not demand their money?
Not after the payment. They accepted the payment, Your Honor. They originally sent an invoice
Yes.
on both of the sold properties. They did send an invoice, which did create a dispute, which is a requirement for the defense of accord and satisfaction. They sent an invoice stating the full amount, what they thought they were owed, 3% of the commission. And defendants wired 1%, as was properly agreed to on a piecemeal sale of property.
Was it properly agreed to? I mean, reading the plain language of the contract, how can you interpret it to be for one property as opposed to the properties listed in Schedule A, as to one or as opposed to them being bundled?
Well, Your Honor, if you read the language.
Yeah, the language in the agreement distinguishes a property in singular as opposed to properties.
Well, actually, Your Honor, paragraph 1 of the contract defines the term property, and the term property is identified, quote, is identified in Exhibit A attached here to, and
Properties is identified, not property.
Your Honor, the language, the term being defined, the bolded term in paragraph 1 is property. Now, there is an explanation that the property includes both properties and a property, but to read it to make the contract make sense, and agreed, it could possibly have been more artfully drafted, but to read it to make
And let's get to that. I mean, these are sophisticated parties.
Yes.
They know how to draft a contract that should say what they want it to say, so that we're not here, right?
Well, our position is
Goldberg Weprin is a law firm specializing in real estate. If they wanted it to be after the 4 properties, wouldn't they have included that in the agreement?
It is included in the agreement. It perhaps could be more artfully drafted.
Where?
Again,
Can you
if
show me so we can all read it together?
If you read the direct language of paragraph 1,
Asking you to read it to us because we don't see that. Or at least I don't, and I gather my colleagues doesn't either.
I am actually going to apologize, Your Honor. I printed out the contract this morning and I realized it cut off page 1.
So then I'll pose another question, because
Thank you
you
very much.
keep on referring to portfolio. But, you know, where is that word listed in the agreement? And certainly, where is it in the agreement that, you know, plaintiff would be entitled to a commission upon this closing of each individual sale?
So it is nowhere in the agreement that they are entitled to a commission.
But you know what is in the agreement, section 3? Bear with me, because now I lost it in my need to, I'll come back, okay? Oh,
So she'll come back.
Section 3, provided that the commission will be paid in full upon the closing and transfer of title to the property, record 60 and 71.
Correct, Your
Not the properties.
Correct. Property, in order to have the contract be consistent and not have superfluous terms, property encompasses all 4 properties identified in Schedule A, in Exhibit A. And that's the only way that the rest of the contract makes sense.
Why not just include that in the agreement, counsel?
I cannot speak for how it was drafted, but the only way the rest of the agreement makes sense is if the property includes all 4 buildings. You're
So
referring to them as a portfolio.
Is there a definition provision that says property means all 4 properties? I mean, I'm sure that whoever drafted this sort of knows that if you mean by property, you want to be understood as meaning 4 properties, that you have a definition section saying that, right?
Paragraph 1 is the definition section, but if I can point your honors to further paragraphs in the contract. For example, paragraph 5 states...
There is no definition of the word property to mean 4 properties, right?
It states that it's identified as the property, as Exhibit A, and Exhibit A lists 4 properties.
Let's look at Section 8. So how should we even look at Section 8? Because it says, you know, that a commission would be paid at closing upon delivery of a deed. So there's going to be a deed for all 4 properties. It says a deed or other instrument of conveyance.
So there will be more than one deed for each property. That is correct. However, the contract consistently uses the term property to refer to all 4 properties. I would direct your attention to paragraphs 5 and 6, for example. 5 states, owner may withdraw the property from the market at any time. It's very clear there that the property refers to all 4 buildings. It would
Wait a
be-
minute.
Thank you. So let me just say this. They're going to have a lot of questions for you on rebuttal. That's when we're going to do it. We're moving on to the respondent. Thank you.
Good idea.
Good afternoon.
Good afternoon, Your Honors.
Is there anywhere in the agreement that defines property to mean all 4 properties?
Your Honor, it's exactly the opposite. If you look at Section 1 of the agreement, which is on page 67 of the record, it defines property as each of the 4 properties listed on Exhibit A, and it defines properties, plural, as all 4 of them collectively. It's exactly the opposite. And I'd like to say, Your Honor, if these sophisticated parties who were represented by experienced real estate counsel wanted to draft an agreement that made the commission schedule contingent on the sale of all 4 properties as a package, that is, as a portfolio, which, by the way, does not appear in this agreement, they could have easily done that. They could have included a single sentence. It could have said, this agreement shall only apply to a sale of all 4 properties together. It could have also...
Isn't that even taken further by paragraph 8, which says if during the term owner sells all or any interest in the property?
That's exactly right, Your Honor. I was going to say they did exactly the opposite. They provide in Section 8 that not only would a commission be due to Avison Young if a property was sold, but even if any interest in a property, any portion of a property was sold. Owners have never provided an explanation of how they can reconcile their position with that. I'll also add, Your Honor, that in the commission schedule, it provides consistently that
Avison Young would be due a commission, would be paid commissions on sale transactions, meaning multiple commissions on multiple transactions.
Counsel, how do you respond to your adversary stating that you didn't protest to the payment, you just accepted what was given to you?
We did, first of all. That's in the record. But I will also say, this is not an accord and satisfaction. It's not as if what you see in the classic accord and satisfaction scenario where, let's say, owners would have taken a check and they sent it to my client. And on the check it said, this constitute payment in full for all of the obligations. Avison Young took a look at it and then cashed it. That's not what happened here. We sent them an invoice for the entire amount that was owed, and rather than paying it, they unilaterally decided to pay just 1%. And then we protested. This is not an accord and satisfaction.
Because there were phone calls.
There were phone
right?
calls.
There was an email. January 2022, and did the defendant ever respond to
They
the
did
email?
not. And actually, this gets to my next point, Your Honor, which I think is really critical and is telling of what's going on here. Before my client was forced to file a lawsuit to collect what they were owed, owners never provided an explanation as to why they decided to only pay 1%. And once we filed a lawsuit, they say there was some oral understanding before the execution of...
Counsel, let me ask you that. Does the agreement state that any amendments or modification must be in writing?
That is Section 21 of the agreement.
Merger clause.
It has a merger clause which says that this is the entire agreement of the parties. It says that it supersedes all prior discussions. And then they say that there was some prior oral understanding. What's really interesting here is that there's not a shred of evidence in this record about any such understanding. There's no letter, note, email, prior draft agreement saying anything what owners are saying. And this court is clear that a party can't just make conclusory assertions in response to a motion for summary judgment. That's not meeting their burden on summary judgment. And because there's a merger clause, this court has also said that you can't claim that there was some prior oral understanding that covers the same subject matter and look to contradict that. That's not proper. They make an argument that I'm sure we're going to hear on rebuttal about the term gross sale price in the commission schedule. And as the trial court correctly found, and as is clear from the very definition of that term in the commission schedule, that it has nothing to do with selling all four properties in gross, as they claim. What it means is that in calculating the commissions that would be due to Avison Young, you would include not only the sale price, but also any loans or mortgages that were assumed.
Going back to what you stated, they could have also said selling all four properties in gross, which they didn't.
Yes, that is exactly right, Your Honor. The last thing that they say, and this is an
Who
argument.
drafted the agreement?
It was, it was drafted by Goldberg, Weprin, and Avison Young through negotiations. So this was, again, experienced counsel was involved in this.
Goldberg, Weprin on one side, and who was on the other side?
So there isn't actually any evidence in the record as to who was back and forth, presumably because there wasn't anything that was helpful to them in opposition for summary judgment. But I believe, and I see my time has expired. May I make my last point here? Your
Yes,
Honor?
you may.
And that is, they make this argument for the first time on appeal in reply that because we submitted 10 exhibits on our motion that somehow we have conceded ambiguity. Frankly, we don't understand that argument. All we attach to this motion, as you can see, is documents showing that there was an agreement, documents showing that Avison Young performed its obligations under the agreement, and documents showing that owners breached it. It's the pleadings, the agreement, the invoices that were sent, deeds showing how much was paid, the partial payments, and then our protest. This court has instructed time and time again that where you have a clear, unambiguous document that the court should enforce it according to the plain meaning of its terms. That's what the trial court did, and we respectfully request that this court affirm the judgment. Thank you very much for your time.
Thank you.
Your Honors, summary judgment was not appropriate in this case because there are clear questions of fact and ambiguities in the contract. Obviously, if everyone can stand up here and argue as to what property means, then we have questions.
Sorry, I haven't heard any explanation of where the ambiguity arises in this contract. So perhaps I think we asked this before, but I still don't see any ambiguity. Could you point me to something that's ambiguous?
Yes, Your Honor. For example, the term The property is never defined, and yet is repeatedly used throughout the contract. It is used in ways that appear to refer to, like in paragraph 6 and 5, it appears to refer to multiple properties, and then in another paragraph,
Where does it apply to several properties? It seems to me paragraph 1 is very clear that each such property is a property, and collectively they are the properties. Sounds pretty clear to me. So what is inconsistent with that undercuts the clarity of the well-written paragraph 1?
Your Honor, there's no way to read paragraph 5, for example, as just being a single property. Why would the owner have a clause where it could withdraw one property from the market and we don't know which one it is? So the contract becomes unclear if we don't read the properties to be plural. Regardless, as counsel stated on...
Does it matter? Isn't it based on sales? Isn't it based on sales of property? So does it matter that you take one property out of the market? Or two?
You could take properties, but they don't use the term properties out of the market. They're using the term property, and the clearest way to read that...
One at a time.
Is it your position that the only way that we can interpret the contract in your adversary's favor is to assume that any time that the properties had to be sold in blocks, either all sold or none sold? That's the only way they could get a commission? I mean, I don't understand, because I don't see where that is from.
They could certainly get a commission, and if I may just follow up, I see that my time
This is the last question, so you can answer that.
They could certainly get a commission, and this is why the merger clause doesn't apply, because it's not an oral modification to the contract. It is a separate contract it's a separate agreement for the a la carte sale of properties was 1%. The tiered commission under this portfolio agreement only applies to 3%.
Thank you.
Thank you very much.
Hunold versus City of New York.
Good morning, Your Honors.
Good afternoon.
My apologies. If it may please the court. Do you want me to continue without Justice Burke, or
Oh, yes. No.
everything okay?
No, no.
Yes. Go ahead, continue.
Okay. My name's Jimmy Wagner. I represent the plaintiff appellant, Jeffrey Hunold, an 18-year NYPD veteran who was constructively terminated by the City of New York for failing to be vaccinated for COVID-19.
I think it would be most helpful if you would address the issues of collateral estoppel.
Absolutely. This court, and Justice Gesma, I know you helped write the decision on COLA, and I'm on COLA versus the City of New York. I apologize, I thought you were on that panel.
Okay, I was just surprised by your, go ahead.
Well, because in COLA, I'm going to read this quote. It says, Article 78 relief bars a subsequent plenary action, whereas here, the same issues were raised, fully litigated, and necessarily decided. In Hunold, Justice Kim neither fully permitted a full litigation of the issues, nor...
The decision you quoted from didn't say that was the only circumstance in which a subsequent action was barred by collateral estoppel. It was referring to the facts before us at that time. It didn't say that that was the only circumstance where collateral estoppel applied.
Correct, Your Honor. The COLA case took its lead from the Parker case from Court of Appeals, where in the Court of Appeals said that exact quote. Collateral estoppel cannot apply on Mr. Hunold brought in Article 78 when the agency determined he wasn't entitled to a religious accommodation. Justice Kim clearly states the sheet that was given by the NYPD that had 2 checkbox off, she had to use an Article 878 standard of deferential review towards the agency. Justice Kim never applied the proper framework for human rights liability. New York State human rights liability, his plenary...
We're ignoring our many cases that say that claim preclusion, which prevents relitigation between the same parties of a cause of action arising out of the same transaction or series of transactions that either were raised or could have been raised in the prior proceeding. So if they could have been raised, then you're barred. Why doesn't that apply here?
Because in Article 78, as a prior proceeding, is a special proceeding.
But it happens all the time that parties file a lawsuit which has both Article 78 claims and plenary claims, and they're joined together all the time.
Right.
That could have been done in this situation. Since your client didn't do that, there's a bar.
No, there's absolutely, under the CPL law, there's no bar, and the creation of a hybrid proceeding is a judicial creation. It's not a legislative creation.
But he could have done a hybrid proceeding, and having chosen not to do that, then he's got a problem with issue preclusion.
No, well, I would say that if that's the stance, if the court is saying as a matter of law, a public sector employee can either bring all their claims in 4 months, or they're precluded from ever addressing human rights discrimination, I would say as a rule of law, that is a very, very bad rule of law that this court would be setting as precedent, because that is not what the Court of Appeals has said. The Court of Appeals has clearly said that if an issue is fully litigated, there was no discovery here, it was decided completely on Article 78 papers. What this court would be doing then is superseding the legislative mandate of a 3-year statute of limitations. And just 2 weeks ago in Doherty, a panel agreed with me that the statute of limitations for human rights claims is 3 years. There's no need to compress them into this 4-month period of a special proceeding under Article 78. Under Article 78, this man was just attempting to get immediate relief and be restored to his job. That was it.
Tell me, what acts of discrimination did you allege in this case that's different from the ones in the Article 78? And the reason why I'm asking is because, when you compare both of the documents, it seems to me they're one and the same.
Okay, thank you for that question, Your Honor. If we take a look, this record is substantially more robust than any of the previous records, including the deposition of Michael Melikowski, and this is, the deposition's taken from a different case. This is the city's 3211 motion.
Right, I understand, but let me say, when you look at the two petitions, well, the petition, the complaint, seems to me that the claims are one and the same. So I'm asking you, in the amended complaint, where do you allege, discriminatory conduct that's different from what you claim in the Article 78?
If you go through the Article 78 petition under each cause of action, it literally states arbitrary and capricious, arbitrary and capricious, arbitrary and capricious. Arbitrary and capricious is a separate standard. The cause of action for discrimination, as alleged by Mr. Hunold, is that, and it's substantially more than he's made in the image of God. He says, I'm made in the image of God, my body is a temple of God, and abortion is a sin. For those reasons—
What is a sin?
Abortion.
That's not an issue in this case, is it?
It is an issue. That you just asked, why was the discrimination that was alleged? Under his reasonable accommodation—
Look, finish that, because that's going to be the last response, and then we're going to hear from the respondent.
Under his reasonable accommodation claim, he says the reason I can't take the vaccine is for those 3 reasons. Under the structure set up under New York City human rights, at that moment in time, the employer was required to figure out an accommodation under this court's ruling in Hosking that could accommodate this veteran cop of 18 years.
Thank you.
Good afternoon, Your Honors. May it please the court, Hannah Sorokin for respondents. Your Honors, the complaint here is precluded. It's challenging both the Article 78 and the amended complaint here challenge the exact same denial of the religious accommodation request, the same transaction, and is thus the complaint here is precluded. And both claim preclusion and issue preclusion arise here in Justice Kim's decision in the Article 78 proceeding. The court stated that the plaintiff there, the petitioner, did not provide quote, a cogent explanation why his religion or religious beliefs conflict with vaccination. That's the exact same issue here. That's the exact same issue in COLA, the exact same issue in Doherty. I'll note in Doherty there was not a prior Article 78 proceeding, so that argument, I believe, I'm not sure.
The argument goes, I have 4 months to do an Article 78 proceeding, and I am raising these claims. Now, I want to file a plenary action for city and state human rights law discrimination. And so I should not be precluded from filing those actions.
The issue here is trying to take a second bite at the apple. So by bringing that, so in the Doherty case, there was no prior Article 78. And in appeal, we agreed that the court had incorrectly applied a 4-month statute of limitations.
Doesn't that result really mean that a city or state employee is deprived of the 3-year statute of limitation under law for discrimination actions?
No, Your Honor, and this court has applied preclusion in, that has stated that a prior, apologies, Your Honor, a hybrid action, simply because the prior action was in Article 78 and constricted by that 4-month time period. This court has done that in, for example, breach of contract claims. The issue here is like I said, taking that second bite at the apple by bringing in Article 78, where the court is considering whether the denial of the accommodation request was contrary to law. So it's necessarily deciding whether, essentially the merits of this case, that is then a final determination. It was unappealed. And then now essentially attempting to take a second bite at the apple, having already had that decision by challenging those actions again. If he hadn't brought that Article 78, we would agree that the 3-year statute of limitations applies. But as this court's precedent has been clear, when an issue is decided or necessarily decided, it cannot be brought again. And claim preclusion also applies because it's the same.
So you're saying that regardless whether or not he labels it a state and human rights law discrimination action, that this is exactly the same thing that he claimed when he brought the Article 78?
Essentially, it was necessarily decided. The issue was already necessarily decided. And for those reasons, I'll also just, if I may, just briefly address the merits here. The failure here is that there's no allegation, as Your Honor's pointed out. It's essentially the same allegations as Cola, as Doherty, and this court has already found that he needed to allege a connection between his religious belief and his alleged inability to obtain the vaccination. He simply did not do that. By simply stating, as a Christian, he is created in God's image, that does not allege an inability to obtain the vaccination or that he conveyed that to NYPD.
He didn't include a demonstrated history of vaccines or medicine refusal.
Correct.
Is that your argument?
I'm sorry, I didn't hear the first part of.
He didn't submit anything to demonstrate a history of vaccines or his refusal to take them, did he?
That he did not hear, but even without that, the allegation alone is plainly insufficient, as this court has already held.
Thank you.
Thank you.
Your Honors, Justice Mendez, you hit the nail right on the head. What we're doing here is we're precluding public sector workers from ever being able to exercise a discrimination claim if they are wrongfully terminated and they bring in Article 78. There is nothing in the law that permits that to happen. There's nothing in the law that compels or forces Mr. Hunold to have to bring this hybrid proceeding that is very rarely used. That is very rarely used, and it's very rarely used for the very reasons that are set forth here, is that you cannot build a case in 4 months for discrimination. It takes discovery. Under the underlying Article 78 case, there's absolutely no litigation. There is no discovery, no depositions. Justice Kim literally said, I apologize. Under Marstella, I have to defer to the agency, and I'm going to deny this Article 78. Mr. Hunold, recognizing Marstello comes down, brings his plenary action. At the same time, he files a brand new and says, I suffered discrimination. Once he states he suffered discrimination, he discovered discrimination because he is a Christian, we've attached to in the record is the expert's report showing that pre-COVID, 99% of all religious accommodations for NYPD officers and New York City employees are granted. During COVID, 8% were granted because the city, through DCAS, through the agency of the NYPD, put in place a policy to deny our public sector workers their constitutional rights and statutory rights. That was never, ever addressed by Justice Kim. In fact, Justice Kingo lumps the collateral estoppel and res judicata under 3211A7. If you look at the notice of motion, they don't even notice res judicata or collateral estoppel. Justice Kingo says 3211A7, I'm just gonna lump in res judicata and collateral estoppel. That's correct, Justice Gesma. Just look at the notice of motion.
Thank you. Gopstein versus Vad.
Good afternoon, Your Honors. My name is Mark Retchney with the law firm of Kaufman, Bordeson, Ryan, and I represent Dr. Vaught. Your Honors, this court should reverse the motion court's order because Dr. Vaught established he was entitled to summary judgment with the expert affirmation of Dr. Garibo, and plaintiff failed to raise a tribal issue of fact in opposition. Plaintiff failed to raise a tribal issue of fact for at least two reasons. First, plaintiff's expert completely failed to address, let alone refute, any of Dr. Garibo's factually specific and evidence-backed opinions. And second, plaintiff's expert's own opinions were in fact contradicted by the record, specifically of plaintiff's reporting of pain after the procedure. So Dr. Garibo opined that the onset of plaintiff's symptoms is completely inconsistent with the type of direct nerve injury that he alleges. Such an injury would have included immediate symptoms that persisted.
Why isn't this a case of conflicting expert affidavits that should go to before a jury?
Because plaintiff's expert completely fails to address any of Dr. Garibo's specific opinions that were in fact backed by the evidence and factually specific. And in fact, one of those being the fact that the injury that plaintiff claims he alleged would have included symptoms that were immediate and persisted. That is not the case with the record evidence.
Does the expert have to address every single, the plaintiff's expert have to address every single position taken by the defendant's expert? Or could they address, in this case, the pressure that was used, the excessive pressure, the excessive power, they addressed that, but maybe they didn't address the needle size or something of that nature. Does that somehow make their expert's affidavit less, I don't want to say reviewable, but carry less weight?
Well, if they had even actually addressed the issue of high pressure and with what Dr. Garibo specifically said about that, that would be another case. But with going on what you were referring to, the issue of high pressure, Dr. Garibo specifically explained that the use of the term high pressure was referring to irrigating the epidural space and not the speed of the injection or the force of the injection as plaintiff's expert as seems to be alleging here. Specifically, Dr. Vads, and he admitted that he misspoke when he used the term high pressure. He explained that he used the term high pressure to refer to the saline irrigation being introduced under high power, not the syringe or the physical act of injection. That's on page 364 of the record. He said,
he misspoke.
Correct.
Allegedly, he misspoke. That's an issue of credibility, no? He misspoke. He said one thing, then he said something else.
Well, what he specifically said, I used the wrong word, yes, should be high power saline irrigation. He specified what he was referring to. I understand that some words can be ambiguous, but in this case, there was an explanation specifically by the doctor as to what he was referring to there.
Let's go back to that, just to follow up on what my colleague said. If we're talking about high power, high pressure, certainly the plaintiff's experts said, you know what, that's contradictory, and also there's nothing in the medical literature that supports that type of technique. So, it is a battle of the experts, because you have one expert saying one thing, and then you have the plaintiff saying something else.
Well, if the plaintiff's experts specifically responded to what Dr. Agarabo explained in this case, which was the fact that irrigating the epidural space and coating an inflant portion of the root that is outside and inside the foramen, as well as inside the spinal canal with the saline interrogation. Dr. Agarabo explained that the goal can only be accomplished with a certain degree of push on the plunger to get the saline and medication through the foramen into the spinal canal. This infusion of fluid and medication will not create any actual pressure on the nerve root because the medicine will simply back out into the soft tissue when the foramen becomes pressurized. Now, that's a specific evidence-backed opinion, whereas Dr. Agarabo says, nope, you just use the term high power, therefore that can't create a simple conflict of experts, because there has to at least some addressing of the defendant's experts, which also includes the fact that the type of plaintiff symptoms do not correlate with the type of direct nerve injury that plaintiff alleges here specifically.
So could you explain why you think your client was entitled to summary judgment on the informed consent issue, where the consent said only that the procedure was to be performed at the L4 level only, and your client incontestably also performed the injection at L5?
Because in this,
based on that, how can you get summary judgment?
because the cause of action for lack of informed consent is in reality a cause of action based on this court's precedent for battery. And a cause of action for battery has a lower statute of limitations, obviously, than a cause of action for informed consent. This court's precedent, both in Messina versus Matarazzo, Cross versus Cohen, Wiesenthal versus Weinberg, as well as Oates versus New York Hospital, makes it clear that when the claim is based on a complete alleged lack of consent, that sounds in battery, not medical malpractice, and is governed by a 1-year statute of limitations, which the plaintiff did not meet in this case.
Thank you.
Thank you.
Good afternoon, Your Honors. Sheldon Gobstein, plaintiff. Under Fry versus Montefiore Medical Center, we know that conflicting affidavits by well-credentialed experts usually result in a denial of summary judgment. That alone, I think, in this case would be sufficient, but we have much more. We not only have one expert saying that high-pressure technique is nowhere found in any of the literature, high pressure, high power, whatever term he wants to use, it's not a squirt gun. It's supposed to be injected slowly and carefully, so that doesn't fly. It's nowhere to be found. There's also the whole issue of trying to reproduce the patient's pain. The plaintiff's expert characterized the ill-fated attempt to reproduce pain as a gross departure. So that alone would be enough.
Is that what your expert says is nowhere in the literature? That attempt to reproduce the pain?
Both. Both the high pressure technique, the high pressure, high power technique is nowhere found in the literature. And I don't know of any literature that supports the intentional reproduction of pain when you're there to alleviate pain. I haven't found it. They certainly didn't produce any independent articles. But the point I wanted to make here is we have peer-reviewed medical articles that the doctor himself sent to me. He emailed these articles and they contradict what he's saying. And I read those articles to him at his deposition and he said, I disagree. The particular article is at page 1445 of the record. 1445 of the record says that the injection is supposed to be done slowly and it's generally pain-free. It's not that uncomfortable. That's why you don't need a sedative. The pursuit of a pain response from the patient during an epidural was characterized or described by my expert as being a gross departure. And so at the very least, I think we have competing experts that would ordinarily result in a denial of summary judgment. But here we have more. We have peer-reviewed medical articles introduced by the defendant that contradict his position and contradict the defendant's.
Did the consent form encompass the injection to the L5?
Thank you for asking me. It actually does. It specifically says the L4, that's what it's saying, in big bold letters, it says you hereby consent to a procedure at L4, but this is what else it says. And let me be accurate. It says, I understand, may I finish the answer? Oh.
You still have time.
I understand that, I'm sorry, during the course of the operation procedure, unforeseen conditions may be revealed or encountered, and that surgical or other procedures in addition to or different from those described may be necessary or desirable. So in fact, I did consent to the L4, and according to the consent form, to additional or desirable, or necessary or desirable additional procedures.
Even if you're not informed, he can go ahead and do the additional procedures.
Well, no, the consent has to be informed consent, and that's why, that's my point here, is that there was consent, there was general consent, but it was not informed consent. He never, at the end of the procedure, when he says, let me try something, I mean, I'm laying on my back with a needle in my spine, and he says, let me try something. He doesn't ask me what he's gonna do. He doesn't say what he's gonna do. He just goes ahead and does it, and I scream in pain, but according to the law, I did technically consent to an additional procedure, but it's an issue of fact. Was it an unforeseen condition, and was it necessary or desirable? It's an issue of fact. So there was consent. The statute of limitations for battery does not apply here. It's the 3-year statute. If you have any other further questions, I'll waive the balance of my time.
Thank you.
Thank you so much.
Your Honors, one of the things that Dr. Garibo does clearly explain in his opinion is the fact that he already addressed plaintiff's vocal complaint during the procedure. He explained that the vast majority of patients experience such concordant pain down their legs during lumbar injections, when the steroid, not the syringe, which is the only type of form in which this type of direct nerve injury could have occurred, which can have an irritating effect, contacts a chronically inflamed, sensitive nerve. It often reproduces a patient's chief complaint of pain experienced at the time of injury. This is particularly so when there, as we were discussing, there is no local anesthetic administered before the steroid, as here. And that,
What was the purpose of reproducing the pain?
to make sure to address where the patient's complaint of pain was coming from, so that if there's no reaction, then there's not a reaction to the nerve, which is sensitive because of patient's.
But everything indicated that the problem was at L4, right?
Well,
that's where he was going to have the epidural injection.
Prior to that, but because there was no response, that's what Dr. Vaught.
No response in what way? That's why he was injected there, because that's where he had the issue. And then the defendant went ahead and injected another vertebra.
Well, that's why.
To reproduce the pain. So what was the purpose of that?
To reproduce the pain, in order to make sure that the nerve that is actually affected is being treated with the saline and the steroid medication in order to effectively treat that pain that specific nerve is creating.
Mm-hmm. Now, when he signed the first consent form, there was no discussion about, by the way, I also may want to do another injection to L5 to reproduce the pain, just in case, so that I'm sure that your issue is at L4.
And again, that folds into the fact that this is actually not a claim for lack of informed consent. It's a claim for complete lack of consent, which, as this court has held before in numerous cases, is in fact a claim for battery, and it doesn't sound medical malpractice, and is therefore outside the statute of limitations.
Thank you.
Thank you.
will of Lillian Imreich.
Good afternoon, Your Honors. Vanessa Lavely of Cravath, Swain and Moore on behalf of appellant respondent Elizabeth Brimberg. I'll apologize for using some first names to avoid last name confusion for the record. The evidence on which the surrogate correctly denied summary judgment as to undue influence applies with equal force to the issue of whether Lillian Reisch and her son Charles were in a confidential relationship. What the surrogate found probative of Charles Reisch's undue influence necessarily here raises triable questions as to confidential relationship as well. And we would submit that based on that inconsistency, which is not a broad pronouncement that these two issues always rise or fall together, but here, based on the surrogate's findings, we'd submit it's clear that although the court correctly denied summary judgment with respect to undue influence, it incorrectly granted summary judgment with respect to confidential relationship.
Would it be the other way around? That it was correctly granted under confidential, what is it, the first word, I forgot.
Excuse me if I misspoke, Your Honor, that the court incorrectly granted summary judgment with respect to confidential relationship and constructive fraud.
Right, so if the court finds that there was no confidential relationship and no constructive fraud, then it could have erred in denying undue influence.
And we submit that the court, we disagree that that's how they should
You want it the other way
reconcile.
around?
Sure.
Okay,
And I, of
got
course, recognize that that's one way you could reconcile it. I think the court's findings with respect to undue influence are well-reasoned.
So what are the facts that show that there was undue influence?
Sure. I think if you look at the record pages of the opinions, R63 and R64, just to take an example, with respect to the issue of controlling influence on confidential relationship and the similar issue of involvement and opportunity for undue influence, as to confidential relationship, the court found no proof that Charles acted for Lillian in any capacity during the genesis of the propounded instrument, and yet one page later, cited Charles's involvement in the genesis and drafting of the propounded instrument as evidence supporting a claim of undue influence.
How do we look at the evidence from Kirsten and the witnesses under that claim of undue influence?
Excuse me, I didn't hear.
Under that claim of undue influence.
Sure, Your Honor. I think that it depends on which specific, but I think there's ample evidence, both direct and circumstantial, that demonstrates, among other things, Charles's substantial involvement in drafting, which is a key factor for both confidential relationship and undue influence. We have Mr. Keston, who is the lawyer for Lillian Reisch, saying there is nothing to do until after I speak to her son, Charles. That's at the outset of this process.
That doesn't show that he was involved in the drafting. It just says that his lawyer wanted to talk to him.
Of course, Your Honor, and
wanted to talk to him. But that doesn't in any way provide evidence that Charles was involved in the drafting.
And it continues, Your Honor. Charles had several conversations alone directly with Mr. Keston.
There were 4, and it was really limited. So,
Well, we'd submit, Your Honor, 2 of those calls were an hour long each.
But neither of those provide evidence that that the lawyer took Charles's direction as to drafting. And I understood you to say a few minutes ago that Charles was involved in the drafting, but I don't see that the examples you're giving of that actually show that at all.
I think here it's not to say that he was sitting down and actually writing, but he was substantially involved in the preparation and the involvement.
That's different from what you said a few minutes ago when you said he was involved in drafting.
I perhaps meant that indirectly, Your Honor, in the fact that he worked very closely with the counsel. He was meeting with him individually. He called him saying a change needs to get done with respect to the beneficiary account. He's saying, my mother's finally figuring out what's going on, leaving the attorney multiple voicemails with respect to how the will should get done. Even Mr. Keston, his own lawyer, noted that it's very unconventional, the extent of input that Charles had on the estate planning. So I would submit this is the type of case where this court has both found And again, this court need not find that in fact there is a confidential relationship and undue influence. It need only find there are triable facts here, and that's the only question.
No, here, the decedent, was a practicing oncologist. I mean, what evidence was there that she was unable to manage her affairs? Because the evidence really shows the opposite.
In Your Honor, here, there is evidence, obviously, that she was continuing to practice, but at the same time, her mental health was substantially declining in 2015.
Yeah, she suffered from depression. I mean, that's unfortunate, but, going to beauty salons, she traveled abroad, shopping, credit card payments,
Your Honor,
et cetera, et cetera.
If you're saying that suffering from depression is equivalent to not being able to make decisions oneself, then we would have guardianships of a very substantial number of people in this city.
Understood, Your Honor. I think this case, and while it's only persuasive authority, like the case of Gratz v. Gratz, which is applying Pennsylvania law, there were substantial mental health issues that gave rise to questions of undue influence and confidential relationship. The decedent was continuing to work 70 hours a week, and in that case, there was still a finding that one could experience substantial depression that could give rise to vulnerability and susceptibility to influence and inequality, and yet still be able to, in a separate part of one's life, perform your job. And just a final point, she in fact did begin hoarding pills to commit suicide in the very same month where she executed the will. So this goes beyond just depression.
All right, thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Judd Burstein for Charles Reich. I think that it's important to talk about the time periods here. There were two wills. The first will, it's inconceivable that you could make a claim of confidential relationship or undue influence.
And in fact, as to that will, the decedent directly rejected several of her son's suggestions.
Exactly. But there's even more than that. He played no role in selecting the counsel. He didn't communicate with the counsel, Mr. Keston, for 7 days after Ms. Lillian Reich first spoke to Mr. Keston. It's clear from the record that Ms. Lillian Reich asked Mr. Keston to reach out to Charles Reich about technical matters, not about the terms of the will. There is not one suggestion in the record that this will, the November will, had any influence on the part, was influenced in any way by Charles Reich. And you also have the fact from a confidential relationship. This is a woman who, after she met with Mr. Keston, traveled on her own to Peru. She's working as an oncologist at Sloan Kettering. There was no presence of Mr. Charles Reich when the will was executed. The evidence is overwhelming here that there was no confidential relationship and no undue influence. And Justice Gesmer, I think that's the most important point, is the words that Mr. Keston said is that she unwound all of Charles's most extreme suggestions, which is basically to, this is a very dysfunctional family, obviously, that the 50% that was going to Elizabeth Brimberg was going to be in trust, and Charles was to be her trustee.
During the time that before she executed this will, these instruments, did Elizabeth have access to Ms. Reich?
Oh, absolutely. In fact, if you were to look at the record, it's at R5626. It's Ms. Brimberg's affidavit in opposition to summary motion. She said that she spoke with her mother almost every day. They also visited on weekends. It should also be noted that in terms of dependence, the housekeeper said Charles Reich was almost never there, and that's at 5625 at paragraph, that she had a full-time housekeeper. There was nothing that she was doing. And then, so the question is, if there was no confidential relationship as of the will being executed on November 13th, 2015, and there was no undue influence, then there has to be something that would give rise to a confidential relationship and undue influence, something must have changed in that month, other than the fact that Ms. Reich changed the terms of her will. And there is...
Has she given a, well, did she give a reason for changing the terms?
Absolutely. And in fact, it's Mr. Keston. What happened was that there was a lunch with Charles and Charles's wife, the grandkids, and Lillian Reich and her husband Seymour. Lillian Reich, there's no dispute in the evidence. They may dispute it, but there's no admissible evidence that disputes the fact that Lillian Reich came in, was very angry about the fact that that Seymour was going to leave the Quag house that he had only to Elizabeth, and that Charles and his wife Alana said, well, you're going to do something similar for us. And Mr. Reich said, no. And if you then look at what Mr. Keston says about the morning of December 18th, and this is at R2727, this is the morning of execution. We used our time this morning to talk about her motivation in making this significant change and potential and unintended outcomes. Her motivation is to offset her husband's estate plan, which she believes favors her daughter over her son. Now, that was a rational decision by a woman who was working, independent, I think it was Justice Kennedy who pointed out that there are credit card receipts. She was doing everything. In fact, she was shopping, she was going to the beauty parlor, she was buying clothes, she was going to restaurants, she bought her own tickets to Peru during this. It's absurd to suggest that she was independent, she was dependent.
Counsel, Elizabeth alleges that the petitioner's secrecy about the will and the decedent's shows undue influence. But she was always around her mother, wasn't she?
Exactly.
And didn't her mother give her the business card to Mr. Keston?
Absolutely.
And she was around more than her brother?
Yes.
So she could have called the attorney and inquired.
Absolutely. I mean, they knew about it. I just want to make one point, because I know my time is almost up. One of the most compelling facts here is actually the evidence that my adversary seeks to rely upon. Throughout their brief, there's this whole statement about Lillian saying at the time she was in the hospital for having attempted suicide that Charles came out of the woodwork. But in fact, if you look what was actually said, that's a truncated quote. What it actually said, and I'm sorry, I'm just missing, it says, although son Charles seemed very involved in patient's hospitalization, the patient describes him as coming out of the woodwork now. This is June of 2016. Even though we really don't have a relationship and I only see him a few times a year. That is completely inconsistent with any claim of confidential relationship. I didn't get to my other point, but...
Thank you.
Thank you, Your Honors. Just to respond to a couple of the questions that were raised with respect to access to Elizabeth Brimberg, in matter of Mary, I think it's very similar circumstances. There, the objectant was in fact the financial planner for the decedent, and yet the court still found circumstances of undue influence and confidential relationship, and the mere fact of access to the objectant alone didn't preclude a finding that in fact the influence could be exerted as to the estate planning itself. So it need not be influence as to every access of life or complete isolation as to all, and I think that...
What about that's a final statement that opposing counsel made, attributed to Ms. Reich, that she hardly ever saw Charles, and he came out of the woodwork just now. So how does that reconcile with the confidential relationship and the undue influence?
So we'd submit there's ambiguity with respect to the hospital records, which is where that statement is found. Much of the records refer to depression over the past 6 to 8 months, so it's ambiguous as to were they talking about right then in the hospital when he was very much the controlling influence as to preventing Elizabeth from even knowing what was going on with her mother in the hospital.
It was
or
a
whether-
proxy.
Or whether it was talking about earlier. Plus, there's significant additional evidence. There's trips he took her on alone, even without her husband, to Shelter Island. This was all in 2015, indisputably before the will was executed.
For how long were they there?
Shelter Island, they were there for a long weekend. And
One
immediately after that was
It
when
was
she...
a family house, so it wasn't like an extraordinary or unusual trip.
It was unusual for him in that he had reestablished a relationship with his parents towards the end of their life, tried to with his father, was unsuccessful.
Thank you, counsel.
Thank you, Your Honor.
Just want to say two things. One is that we're talking about a long weekend in the summer of 2015, and the record shows that, in fact, Seymour Reich was invited. I don't have it current here, but you'll find in the record that he was invited.
He just didn't want to go.
What?
He just didn't want to go?
Want to go, that's right. And it's in my reply brief, Elizabeth actually was allowed, wasn't allowed, she went to the hospital when Lillian Reich had her attempted suicide. Nothing stopped her from doing it. There was no effort. The last point I want to make is...
I would assume that undue influence often includes an allegation of the person exerting undue influence cutting off the individual over whom they were allegedly exerting influence from other people.
Yes, yes, this is
There's
the
no
case.
such
What?
And there's no similar
There's no
allegation.
proof of that. And the last thing I want to mention goes back to Walther, this court's case in Mazonis, and then just December 31st in 2025, the third department in Hatala. In this, when you're talking about undue influence, forget about confidential relations. When you're talking about undue influence, and you're only relying upon circumstantial evidence, if there is a equally consistent conclusion that can be drawn from that evidence, it's not like any other kind of summary judgment situation. That's what the cases say, and there's a reason for it. Because the whole point of the probate system is to make sure that you honor the testator's will. That's why the proponent has the burden of proof on due execution and capacity. But once you get past that, if you're going to talk about undue influence in the absence of a confidential relationship, it makes sense that the way you honor a competent testator where there was due execution of the will with self-executing affidavits, is to say you have to do more on summary judgment than say, they could find it the other way. If there's a consistent argument that can be made from the same evidence, then summary judgment should be granted.
Thank you. Lexington Insurance v. New York Marine. Good afternoon.
Good afternoon, Your Honors. May it please the court, my name is Shivani Podar from Herrick Feinstein, and I represent the appellant, Lexington Insurance Company. Your Honor, this appeal primarily turns on one issue. Was New York Marine permitted to withdraw its duty to defend the vicariously liable defendants, relying upon extrinsic evidence that did not conclusively negate the potential for coverage, rather. And to set the stage, many things are not in dispute here. The parties agree that the allegations in the underlying action triggered New York Marine's duty to defend, and New York Marine did in fact originally defend. The parties agree California law applies to this dispute. The parties agree that under California law, an insurer like New York Marine can review extrinsic evidence to withdraw its duty to defend. The parties even agree on the standard for what that extrinsic evidence needs to be. It needs to be undisputed and conclusive, which is a very high bar. It's important to understand the standard. What is actually undisputed and conclusive? It's when a fact cannot be contested. And California case law provides us with some examples of what is considered conclusive and undisputed in insurer contexts. For example, when a policyholder concedes to its insurer that its automobile was stolen and he was not the one driving it, that's conclusive and undisputed. When an insurance company determines based on its own investigation that the acts in the underlying case actually took place outside of the policy period, that's considered conclusive and undisputed. And when a traffic collision report, for example, indicates that an automobile was speeding rather than parked, which would trigger coverage, that is considered conclusive and undisputed.
So what's the issue that we need to determine whether or not it was proven conclusively and was undisputed here?
Yeah, exactly. So what is at dispute is whether the evidence that New York Marine relied on was sufficiently conclusive and sufficiently undisputed. And it wasn't. New York Marine primarily relied on questionnaires that it sent to the vicariously liable defendants, asking them about their connection to the bus operators and the driver, the two entities that were covered as insured, named insured.
And some of those responses were just one-word answers or unsworn statements.
Exactly. And then if you review these questionnaires and the answers to the questionnaires, you'll see we don't know who's providing these answers. We don't know whether such persons are qualified to provide these answers. The answers are very brief, like Your Honor said, mostly one-word answers without any explanation, analysis, and without supporting documentation. And the questionnaires also had gaps, issues that were pertinent to agency and alter ego. They didn't ask whether the vicariously liable defendants provided resources or training or were involved in the finances or marketing or ticketed sales, whether they provided any supplies to the bus operators or the driver, whether they shared bank accounts, whether they had same office locations. All of these questions were missing, and they go right to the heart of agency and alter ego.
And who raised those questions that you just mentioned?
These specific questions?
Yes.
These are not only gaps that we identified in the questionnaires, but a year and a half later, after New York Marine conclusively determined that there could be no vicarious liability, these exact issues were revealed in jurisdictional discovery. So in arguing that a lot of these vicariously liable defendants are not subject to jurisdiction, jurisdictional discovery took place. That discovery revealed exactly that these relationships were not only entangled and complex, but that these entities shared finances. They did PR for the bus drivers. They were involved in the ticketing sales. They profited from the ticketing sales. They were so involved, in fact, that after the accident, one of the vicariously liable defendants actually handled the insurance claim for the bus operators. So all of these issues came out in jurisdictional discovery a year and a half after New York Marine determined it was conclusive that there was no vicarious liability. And what's really critical here is the vicarious liable defendants' own counsel reported in a letter that there was a risk that the court's going to find that Twin America and Marmerstein will be subject to personal jurisdiction because they might be an alter ego or an agent of the bus drivers. And the counsel points to 17 different vulnerabilities as to why that could happen.
So in a way, that answers the question, right?
Yeah, exactly. And counsel believed that there was such a major risk on going to a hearing on this jurisdictional issue that they actually said to their clients that we should be advising on settlement. We should be going to mediation, and that way we can delay the hearing on this motion for jurisdictional issue. So in its brief, New York Marine steers clear both of the jurisdictional discovery that revealed all of these inconsistencies in their conclusive investigation, and also steers clear of this letter, the vicarious liability defendants letter. So for those reasons, Lexington respectfully requests that the court reverse the trial court's order.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, Mark Kamen from the law firm of Stewart Smith on behalf of the respondent, New York Marine and General Insurance Company. There is no issue of fact, and the extrinsic evidence that New York Marine relied upon, and which remains undisputed, eliminates any potentiality of coverage for the additional defendants as insureds under the New York Marine policy. The undisputed evidence is SFTS operated the bus tour, SFTS held the CPUC license, the California Utility Commission, which is required for all operators of a charter vehicle. SFTS held the CPUC license. SFTS employed the driver, Mr. Malvar. CS Global owned the bus. SFTS was owned and managed solely by Christian Watts. CS Global.
Wasn't Global also alleged to be in a joint venture with Twin America?
If it was, it wouldn't speak to vicarious liability under the auto policy, because under a joint venture, both parties to the venture would be liable for their own joint participation. The duty to defend is not unlimited, and it is it's measured by the nature and risks covered under the policy. This policy is a commercial auto policy, and in California, they're required to have this vicarious liability provision, providing coverage for anyone liable for the conduct of an insured, but only to the extent of that liability. Meaning, who is responsible for putting the driver behind the wheel and the bus on the road? That's where it ends, and nothing leading to this is in dispute. And that's really where the inquiry ends, and why the lower court got it right that New York Marine was entitled to summary judgment.
Isn't there also an allegation that there's an allegation of alter ego identity between Twin America and ZMSF, which is a part owner of CS Global?
A few things to unpack there. One, CS Global was owned by SFTS and YMSF. So,
And also by ZMSF.
no, ZMFS is an owner of YMSF. YMSF is a minority owner of CS Global. So there's no control over CS Global or SFTS, period.
What evidence in your papers established that, I guess, negated their position that this was maybe an alter ego situation?
So, and that gets to another point that needs to be unpacked. Alter ego is not the same as vicarious liability under an auto policy. Alter ego is a procedural remedy, and it requires corporate misconduct, bad faith on the part of the other entity. That would not be vicarious liability. That's not what's covered under a commercial auto policy. Again, the commercial auto policy it entitles one to coverage where they're responsible for putting the vehicle on the road. Alter ego, single business enterprise, these are separate things. This is a step removed from vicarious liability under the Omnibus Clause.
Just want to go back. What were the undisputed facts, that eliminated any possibility of coverage, particularly in light of the unsworn statements, the one-word answers, relying on documents that weren't even annexed to the motion?
As to any particular entity, I can tell you we didn't even need to get necessarily to the responses to the questions, because based on what New York Marine had, all the control lied with CS Global and SFTS. That there was nothing more. Still, they were entitled to inquire because an insured's required to investigate its responsibilities under its policy. It asked appropriate questions, and it pulled those answers. Those answers just affirmed time and again that these additional defendants didn't share any employees, didn't employ the driver, didn't own the bus, didn't convert the bus. There's really no issue of fact here, which is why summary judgment was appropriately entered.
What are we to do with counsel's letter, in essence, describing the relationship between the entities and the possibility that they could be subject to liability under alter ego theory.
I think that is not dispositive, and it's
Wouldn't that create
relevant.
an issue of fact?
No, Your Honor.
And wouldn't that, in essence, defeat your proof that there is no undisputed issue?
Respectfully, no, Your Honor. This is a conclusion from other counsel.
Yeah, but based on a review, of a lot of things. I mean, I don't think that they came up with that opinion out of thin air.
There's still no issue of fact that led to that conclusion. It's a.
So they're reviewing the files and they're reviewing some other evidence, and they come up with the opinion that, guys, we could be exposed here, so let's try to do something with it.
There's no issue of fact that leads to that conclusion.
Okay.
Thank you.
Your Honors, just 2 quick points. It was New York Marine's burden to prove the absence of even a bare potential or possibility of coverage. What that means is they were to prove that there cannot be any vicarious liability. No alter ego, no agency, no joint venture, no single enterprise. And even if you take alter ego out of that equation, which they're claiming it should be, and we don't agree with that, there were other theories that were alleged, and not all of them were conclusively established, that there was no way to conclusively say that there's no vicarious liability. And what's important is New York Marine fails to cite a single case in which a court upheld an insurer's denial of coverage based on this type of investigation on agency and alter ego theories. And it would set a dangerous precedent that allows insurers to deny a duty to defend, which is broad, not unlimited, but it's broad, based on an incomplete investigation that's unsupported by evidence, and that's coming from someone who is representing an insurance company. Thank you.
Thank you. Stewart versus JMDH Real Estate.
Thank you, Your Honor.
Good afternoon.
Good afternoon, Your Honors. Adam Hurwitz for the plaintiff, appellant, and respondent. It's late in the day, so I'm going to jump right to what I believe is the key argument here regarding the application of integral to the work defense, which we believe the lower court erred on. And in doing so, the lower court created 2 possible additional burdens for the plaintiff in defeating such a defense. One, that we would have to prove that the Masonite board was an improper covering to protect the floor, or, according to the lower court, that there were better ways to protect the floor that had been used previously. And indeed, Bazadaric does not speak of either of those requirements. It does allude to there being, in that case, a safer alternative to the plastic that was put down on the escalator steps, that being the drop cloth, but its decision held 2 important findings. One, that the integral to the work defense doctrine only applies when the dangerous condition is inherent to the task and not, as the case in Bazadaric and the case here in Stewart, where a defendant or third party's negligence created a danger that was avoidable without obstructing the work or imperiling the worker. Its second point of note was that a defendant cannot be absolved of liability for the use of an avoidable dangerous condition or for failure to mitigate that danger, including as specifically provided by the Industrial Code, and in this case 23.1.7 E1 and E2, if preventative measures would not make it impossible to complete the work. In this case, the evidence is clear. We had a masonite board, that was installed by Bar and Bar, the GC. It was maintained by Bar and Bar. And also there was testimony and photographic evidence that what the raised masonite constituted a tripping hazard. Both the safety manager from Bar and Bar testified to that, as did the superintendent. And the photograph that's in the record clearly shows a dangerous condition.
And they were on notice of that.
They were on notice of it. And if you look at the photograph, it would appear, I think, to anyone that there were no attempts ever to put the edge, yes.
1468 of the record.
1468 of the record. That there was no attempt to place that edge that was now raised down to or secure it to the saddle between the pump room and the work area. None whatsoever.
That put the masonite board in the category of an quote-unquote avoidable hazard, like the plastic tarp that the Court of Appeals discussed in Best Eric.
Exactly. Exactly. It was avoidable, and they could have remedied the condition within 5 minutes, arguably, by taking some tape and bringing that board down secure to the saddle, and then avoiding the tripping hazard. What the lower court also fails to do is to recognize the many decisions that have come out of the First Department since Best Eric was decided. That includes the Bowden case, Bowden versus Summit Glory, Lourenco versus City of New York, Zukowski versus Chelsea Warren, and most recently, earlier this year, in Padilla, early this month in Padilla. Let me quickly move on to the other claim. Labor Law 200 claim and the negligence claim, we believe plaintiff should have been granted summary judgment for. I discussed the tripping hazard. There is no question of fact or issue of fact as to the fact that it was a tripping hazard and dangerous. Comparative fault, really quickly. The lower court should have granted our summary judgment motion, dismissed all affirmative defenses regarding to coupled conduct and comparative fault. The court declined to do so for two reasons. One, primarily, it didn't even get to the issue, the substantive issue, because of the fact that we did not specify the precise affirmative defenses that we were seeking to have dismissed. However, it was in our notice of motion. We argued it in our summary judgment papers, and the defendants argued aggressively against our papers or in opposition to that motion. So it was all there before the court, and I know it may be better practice to list these affirmative defenses section by section, but I believe that we have been before this court on many occasions where we have not done so, and I cannot find any rule, regulation, or other case law that would have required us to do so. Substantively, there is no question that if you follow the case holding in Bradley versus NYU hospitals, the simple argument that defendants made in this case is Mr. Stewart should have seen what caused him to fall. And that is pure speculation and is insufficient to defeat our motion for summary judgment dismissing those affirmative defenses. Thank you.
Thank you.
Good afternoon, Your Honors. Darian Bryan for respondent appellants. As to plaintiffs' 241-6 claim, we believe that the court did get it right. The masonite was integral to the work. There was also issues as far as notice.
So the fact that you need to cover the floor and you put this masonite over the floor, don't you have a duty to make sure that it does not constitute a tripping hazard?
That is correct, Your Honor.
And when we look at that photograph, doesn't it look as if it is a tripping hazard?
I agree that it does look so, Your Honor, but my issue, what I'm getting to is that there was also an issue as far as notice.
And didn't the plaintiff testify that he had seen that and that he had complained about that?
So there's a question of fact as to whether he actually did. He testified that he saw it in the morning, but he wasn't sure if it was ever anybody ever complained about it. Mr. Santarufo, the superintendent for the job, testified that he did not receive any complaints about the masonite. I believe Theodore Brownell, also the safety supervisor, testified that he never heard any complaints about the masonite.
And neither of them noticed that the only entrance to the pump room had a obstruction in it that could easily trip a worker?
Based on their testimony, yes, Your Honor.
And isn't this the place where the tools were being kept also?
That's not all the tools. That was the location where Capital Fire's equipment was being kept for their pipes as they were using throughout the site. So there was issues as far as notice. And in regards to the Bowden cases and the other cases that plaintiff raised, at most, I believe those create an issue of fact as to whether the masonite was a safety hazard or improper at the time. And as to our Bar and Bar's points as to Capital Fire, if there's an issue of fact as to 241-6, then Bar and Bar and the other defendants would be entitled to a conditional order of summary judgment for contractual indemnification, because the only reason that was dismissed was because the court found that the only issue was Labor Law 200 and the common law negligence claim. Now that would be, if that's back in play, then we are also entitled to contractual indemnification.
So because the injury arose out of the
In connection with
the work.
plaintiff's work, correct. And it is also our belief that we are entitled to contractual indemnification against Construction Resources, because Construction Resources provided the laborers for the site, and
Did they hire the laborers, or were they just sort of like a conduit, sort of like a union hall?
It was a union hall that Bar and Bar entered into a contract with Construction Resources to provide laborers for the site. They provided the superintendent. They provided, I believe, 2 or 3 laborers for the site to perform the work.
But did they have anything to do with the performance of the work?
The laborers provided did.
But CRC?
The laborers provided by CRC did, Your Honor.
Who paid those laborers' wages?
Construction Resources.
CRC paid their wages?
Right. They were on the payroll for CRC, Construction Resources.
And Barr was obligated to inspect this area, right? In this picture, right?
Yes, Your Honor. Thank you, Your Honor.
All right.
Good afternoon, Your Honors. May it please the Court. Joseph Santiago for third-party defendant, Capital Fire. It is not the case, Your Honors, that simply if plaintiff's 241-6 claim returns, that Bar and Bar is entitled to indemnification from Capital Fire. And that's not the only reason that the court held that they were not entitled to such indemnification. As Your Honor pointed out, Bar and Bar was responsible for inspecting this area, maintaining this area. The testimony is unequivocally clear that Bar and Bar installed the masonite. They were responsible for fixing any issues with it. The plaintiff testified that he brought this to the superintendent's attention, and that the superintendent also testified, had he known of this issue, he would have made sure that it was fixed. His labor foreman would have done so. So Bar and Bar, if they're liable to plaintiff at all in this case, it's because they were negligent in the maintenance of their boards. And if that's the case, they're not entitled to indemnification for their own negligence, whether that's premised on 200, common law negligence, or the 241-6 claim. So our position is that either way, that Bar and Bar is not entitled to indemnification from Capital Fire. To briefly address plaintiff's arguments, as to the 241-6 claim, as Mr. Bryan pointed out, I think at most this would entitle plaintiff to an issue of fact on 241-6. He wouldn't be entitled to summary judgment on it. The Basdarack case, as the court pointed out, the reason the lower court brought up those issues in Basdarack, they were distinguishing based upon the facts. The plastic covering in that case, the defendants admitted that's the wrong thing you're supposed to use for that work. We have other alternatives on site that are normally used for that work. So in that case, you have the defendants admitting this was the wrong thing to use for the work, so it couldn't be integral to the work. Similarly with Bowden, the newer case that plaintiff cites in his brief that came down after this case was decided. If you look into the filings in Bowden, in the statements of facts that the plaintiff and the defendants raise, the work in the area where plaintiff was injured was actually complete. So the masonite board on the site should have been removed at that point. So it could not have been integral to the work because the work was done in that area. It served no purpose. So I would just distinguish Bowden on that fact. And unless your honors have any other questions for me, I'll rest on my brief.
All right, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Anu Burgawa on behalf of Construction Resources Corp. of New York. Your Honor, as to the third-party claims, one single issue before this Court is that can a union paymaster, whose role is purely administrative, be required to indemnify Bar and Bar for an accident that arises out of Bar and Bar's construction work? Your Honor, the Supreme Court correctly stated no, and this Court should affirm that decision for the following reasons. Your Honor, the indemnity clause in the agreement between Bar and Bar and Construction Resources states that claims arises out of the subcontractor's work. So the threshold issue is, what is CRC's work? Your Honor, the record is clear. CRC was responsible for only supplying the laborers, processing the payroll, insurance coverage, and union compliance. Construction Resources was not performing actual construction work at these sites. They were not supervising these laborers, was providing directing the means and methods, or even installing this masonite that was involved in the plaintiff's.
So who employed the superintendent and the foreman and the other three laborers?
Your Honor, the Peters Santarufo was Bar and Bar's superintendent. He testified that he worked for Bar and Bar for 26 years. And when Bar and Bar stopped being a union signatory, that's when Bar and Bar retained Construction Resources to provide people like him and other Union 79 local laborers to continue or to remain on a union payroll and continue to work for Bar and Bar, Your Honor, not CRC. CRC had no control authority over these workers. They had no site presence at the time.
So in order for these workers to maintain their union affiliation, they would need to work wherever CRC sent them to work?
Yes, Your Honor, and to prevent this type of friction that counsel mentioned, we have a special employee doctrine. And that's when Bar and Bar was responsible for maintaining them, providing them safety, materials, and installing the masonite that was involved in the plaintiff's accident. And Your Honor, if we have to go with Bar and Bar's theory, then every payroll administrator would become a guarantor of a job site with not even having any presence at that work site.
So what is your, what's your profit here? How do you profit if you send workers to Bar and Bar?
Your Honor, we get...
And you pay their as you say, you're the paymaster.
Yes, Your Honor, the agreement is that we perform all the administrative functions. For example, the payroll processing, the union coverage, and that's how we get paid for providing all these administrative functions that are required to make sure that these employees remain on a union payroll while continuing to work for the subcontractor, and they're on their watch to be supervised, directed, controlled, and provided all the materials and safety equipments.
Thank you.
Thank you, Your Honor.
Very briefly, as to the issue of notice, they created the condition. That's first of all, okay? And if we are going to believe the testimony from Bar and Bar's employees that they never saw it, thus they had actual notice of it, they must have seen it or should have seen it when they were walking this site, inspecting this site 3 times a day. That goes to the argument about notice. Now, relative to whether masonite might have been an appropriate device, maybe it was. Maybe it was the best device. But putting down a defective piece of masonite and not securing it properly does not give you the opportunity to then say, hey, it's integral to the work. It becomes an inappropriate device in the condition in which it existed as of the date of my client's accident. Quickly on Bowden, again, I've read the case, and I know that Judge Kennedy, Mendez, Kapnick were on that panel. Excuse me, yeah, they were. And I see nothing in there of distinguishing this case at all from the case at bar. Thank you.
Thank you.
Sorry, Your Honors. Just want to quickly touch on the common law negligence claims. So in regards to our contractual claim against Capital, we believe that we would be entitled to a conditional order of summary judgment simply because the lower court found that there were questions of fact as to bar and bars and the respondent's negligence as to Labor Law 200 and common law negligence. Should 241.6 come back in play, and there be issues of fact as to 241.6, then we would rightfully so be entitled to a conditional order of summary judgment as to contractual indemnification against Capital Fire.
Just to follow up on CSC, you know, how did you establish that plaintiff's accident arose out of the, CSC's obligation to be the paymaster and supply union workers? How did you establish?
Sorry, you said how did we?
Yeah.
How did we? Because Construction Resources provided the laborers, they provided the superintendent and laborers were on Construction Resources payroll. Their work was to do construction work at that site as laborers and the superintendent under Construction Resources.
All right.
Thank you.
Thank you. People v. Martin. Good afternoon.
Good afternoon, Your Honors. May it please the court, Lawrence LeBrew, on behalf of Mr. Michael Martin. The court has two applications for relief in the form of the appellant is moving to dismiss the indictment, and if the indictment is not dismissed, the appellant is moving.
Counsel, on the 3030 issue, on 6/23, the people stated not ready for a necessary witness out of the country. On July 21st, the people were not ready. The ADA was on trial. Then they filed a statement of readiness off calendar on August 2nd. And then on September 14th, they were not ready again, the witness being out of the country. My question to you is why, and I understand that you want us to find the 8-2 statement of readiness illusory. However, the people have offered different reasons on different dates as to why they were not ready. How have you shown proof that the 8-2 statement of readiness was illusory?
Well, as a threshold matter, in the post-readiness situation, the people have the burden of providing a record of the underlying facts regarding delay. That's People versus Cordes, 80 NY 2nd 201.
And the people, and I just went through what the people said.
Right. Our position is when the situation involving the people producing witnesses, the people have to show due diligence that you've taken some meaningful steps to produce a witness if you're alleging exceptional circumstances for a witness not being there, okay? Due diligence requires use of the criminal procedure law and the necessary options available via the criminal procedure law to get a witness in the court.
Such as serving the witness with a
They
subpoena?
could have subpoenaed the witness. If they subpoenaed the witness and that didn't work, they could have got a material witness order. Okay, a material witness order doesn't require a witness to be jailed. A judge can issue a summons asking that witness to come into court. He's appointed counsel. They have a hearing and determine.
Do you want to alienate your witness when you state ready, and then a day or two before the witness is supposed to appear, the witness tells you that he's or she are going on vacation, are going to be out of the city, out of the country, out of the state? you're going to serve them with a subpoena saying, well, you got to be here.
Well, that's the choice that
Or you want to work with your witness to see if you can get them to come in and voluntarily and assist in the prosecution.
And I understand the court's position. That's a decision that the people have to make. The people have to engage in a balancing process. Do you want to let this witness go on vacation when you've charged the defendant in an indictment, okay, with a felony, and you're the one bringing the charge? So if you choose to let your witness go on vacation, you should be charged.
I don't know
Counsel,
if that
I'm sorry.
necessarily answers my question. While I'm not disputing what you're saying, I don't know if that answers my question as it applies to the off-calendar statement of readiness, then the people being not ready. You want us to find that it's illusory based upon the fact that they have now been, the witnesses out of the country, but they changed the reason. Now, there's a strategic thing, and if we look at certain cases, that might be allowed, or maybe makes that the time not chargeable to them. I think you need to focus on that.
Let me focus on that. The Court of Appeals and the appellate courts have specifically said that when the people file an off-calendar statement of readiness, and then they come back on a court date and say that they are ready, then they have to provide a reason as to what happened between the time.
Counsel, they did. Here. The Court of Appeals in People v. Brown held, a statement of readiness is presumed valid, and a defendant who challenges such a statement must demonstrate that it is illusory by showing that the people were not actually ready at the time they filed it. Judge Pitt-Burke explained that on June 23rd, they answered not ready, despite filing a certificate of readiness on May 20th. They explained that the case had been reassigned in the interim, a necessary witness was on vacation, and could not be there. Bear with me. And on September 14, again, the people answered not ready, despite filing a certificate of readiness on August 2nd. The people stated that they did not answer ready because two necessary witnesses were out of the country, and they gave the judge an email showing that. So again, what Judge Pitt-Burke asked you, how have you proven that they were not actually, how have you shown that they were not actually ready when they said they were?
And here's how I have shown that they were not actually ready. As soon as the people said that the witness went out of town on a vacation, automatically they were triggering an exceptional circumstance under the statute. That once you trigger an exceptional circumstance, then the people have the burden to show that they, in effect, have an exceptional circumstance. And we cited the case law in our brief. To have an exceptional circumstance, the courts have specifically addressed this issue and said that a witness going on vacation, an ADA getting assigned another case, that is not an exceptional circumstance. The courts.
You can answer that, and then Justice Gesma has a question. That's going to be the last question, and then we're going to hear from the respondent.
Thank you. Thank the court. The courts have specifically said once you invoke an exceptional circumstance, depending on the factual predicate that you invoke it under, you have to make a showing. If you're saying a witness is on vacation and you're invoking an exceptional circumstance because you don't have that witness, then you have to make an showing that you did some due diligence to get that witness there, because just the witness going on vacation based on the statute, that's not enough to get an exclusion, because the overriding purpose of the statute is to determine, are the people ready for trial? Especially when the purpose that the statute was initiated was to focus on the people's readiness. Okay, so when the people say they don't have a witness, they automatically are invoking a statutory exclusion, which requires them to meet a certain standard. So the appellant in our brief is saying they didn't meet that standard.
I want to turn to the other issue you raised. Assuming we were to agree with you that that Detective Lee should not have been permitted to testify, to identify the defendant in the video and in the photographs, why wouldn't we find that that was harmless error in view of the many photographs and in view of Ms. Hecker's testimony?
That error is not harmless in the fact that for a couple reasons, Your Honor. First, when this court and the Court of Appeals has laid down the criteria when they let an officer who doesn't have firsthand knowledge and doesn't know anybody related to the crime come in and testify. Now, to focus to your question, as a threshold matter, we submit they don't meet that criteria. Okay, now, in this particular case...
Right, but assuming we found they meet the criteria, why isn't it harmless error?
It's not harmless error because there's photographs that are, but there's no actual video showing the defendant committing a crime, and it's not harmless because the officer's testimony, in effect, acts as a form of expert testimony because he doesn't have any firsthand knowledge. He was not there. He doesn't know anybody involved in the case, and yet he's coming in forming an opinion about an artifact on a photo or a video, and he's giving that opinion to the jury. Okay, so notwithstanding the fact that there's some other pictures and there were some objections there and what have you, the question becomes, what force does that have on the jury's deliberative process? And our position is, especially when it's a police officer who's an employee of the district attorney's office.
All right, thank you.
Okay.
Thank you.
Good afternoon, Your Honors. May it please the court, Addison Esley for the people.
Counsel, I just want you to start at that point, talking about the detective's identification, because Mosley would seem to stand for the proposition that the familiarity needs to have taken place prior to the arrest. I know that we have case law that has at some point said that post-arrest familiarity is okay, but Mosley changed that. And since then, this court has not necessarily held that that kind of lay witness testimony is sufficient unless there was something else. Maybe the video was chaotic or grainy and it needed to aid the jury. But still, you had to have this level of familiarity. How do you show that here?
So the familiarity that Lee had here, Your Honor, was that when he arrived after the shooting to investigate it, he watched the video and was aware from all the information that the other officers there had told him. And then he watched this video and then subsequently gains more familiarity after the arrest. But prior to the arrest, he had already seen the video of defendant and viewed all of this.
So your position is that because he was able to view a person on the video and then he arrested someone who matched the person on the video, that's the sufficient familiarity?
Your Honor, the key question here is whether Lee would be more likely to identify defendant on the video than the jury could be. And with his...
I don't think that's the key question under Mosley. I think the key question under Mosley is there sufficient familiarity prior to what seems to be the arrest, right? That would allow for this person to now make this identification on the video. And then the second step being, does it aid the jury?
Your Honor, I would have to give you that he does lack familiarity going into the arrest. He gains most of his familiarity from the arrest. But I do want to point out that Hecker, who was an eyewitness to this...
But that doesn't answer the question about Lee, which I think...
It goes to Your Honor's point about harmless error, where...
But I'd really like to hear the answer to my colleague's question.
If Your Honor is focusing on the pre-arrest familiarity, I will have to say that Lee is quite lacking in the pre-arrest familiarity. He watched the video, he's aware of the description.
In the Court of Appeals in People v. Mosley, stress that the witness who would be allowed to do this kind of identification should have familiarity on more than one day and in more than one circumstance, and ideally on the street, which isn't true of Detective Lee at all, is it?
No, Your Honor. I would have to say that Lee is not as familiar as perhaps I would have liked, or the people would have liked, but he nonetheless had this information from his officers.
Is his testimony, does it then become harmless error, and how so?
So any error with that would be harmless in admitting that identification. One, because Hecker did identify defendant on the video as well, and Hecker was an eyewitness, and Mosley, by its terms, applies to the non-eyewitness identification on video.
Wouldn't we expect, as counsel argued, that the jury would give greater weight to testimony and identification testimony from a person who's been in the criminal justice system as a prosecutor and now as as a detective and now in the DA's office?
Perhaps, Your Honor, but ultimately the judge gave several limiting instructions here to the jury and told them that it is their province to make this identification themselves. And while they may rely on Lee's testimony, A, they're not supposed to give more weight to it simply because he is a police officer, but B, ultimately they are still the ones tasked with making this identification.
But why was his testimony necessary for the jury, given that there was Hecker's testimony and there were all these photographs? If he was so clearly identifiable in the photographs, why was it necessary to bring him in to testify?
It was just another helpful aid to the jury, Your Honor. It was
That's
more...
not what People versus Mosley
I just want to
says.
go back on that, because you said helpful, because how did the people establish, what, the video, it's not clear, it would be difficult for the jury to, identify, and that's, why we would need the detective. He would be able to, assist. Was that even done in this case?
Would Lee's testimony be able to assist because the video's clarity?
Did you show that in your case?
Yes, Your Honor. The videos here, there are moments where defendant himself is clearly seen, but these videos shift perspectives multiple times, and it was helpful for the jury to have Lee's testimony sort of tying all these videos together.
How did you show that? That's what I'm saying. How did you show that?
By having Lee identify defendant in each of these videos, Your Honor. And then ultimately what this is getting...
The standard in Mosley isn't whether or not it's helpful, but whether it's necessary.
Yeah.
Which you haven't addressed. Why was it necessary?
Your Honor, I don't know if it would be necessary in that case, but in any event, that would then get to the harmlessness of it, which is that...
And Mosley allows for harmless error in these situations.
That's correct, Your Honor. So ultimately...
But you still have to tell us why it's harmless.
It's harmless, Your Honor, A, because Hecker identifies him on the video as well, and so from that, the jury can still piece together, and then B, defendant's wearing the same outfit in each of these videos, and C, matching up the timings of each of these videos, you can see clearly defendant walks out of this lobby, and then there's the shooting that occurs outside the NYCHA building, and then Watson, the victim, comes back into the building holding his lip as he's now bleeding from the lip. And I do want to point out one thing that my colleague said. There absolutely is a video of defendant shooting in this case. It's People's Exhibit 1.1, and on page 9 of our brief, we lay that out. And
That makes it all the more questionable why his testimony was necessary.
Yes, but doesn't that show that there was overwhelming evidence that this was the defendant that did the shooting?
Yeah. To put it this way, Your Honor, the way we lose on Mosley, I believe, is that the video is clear enough that the jury would have identified him anyway, in which case it would be harmless.
Thank you.
Thank you, Your Honors.
Briefly, may it please the court, our position is that the testimony of the police officer, parole officer, was not harmless error. The testimony in and of itself was unduly and
So that witness, Hecker, she knew this defendant from when they were children, correct?
Correct.
She was there, in essence, when this is taking place, correct?
Correct.
She identified him in the video, correct?
Not as the shooter, no.
Not as the shooter.
No.
He was wearing distinctive clothes, as seen in the video and as seen at snippets taken from the video.
It's my recollection of the trial. She never identified him in a video as a person who shot the victim. That's my recollection from the trial.
She testified that she didn't see him do the shooting.
Correct. Now, our position is that that police officer's testimony was unduly and unnecessarily suggestive for the simple fact that he focused on Mr. Martin as a defendant, as a possible perpetrator before he made any identification. Mr. Martin was the target before he made any identification. So as Martin is the target, here's the video, that's Martin. Okay, so our position is that it was unduly and unnecessarily suggestive and it was not harmless error. And I just want to go back to the 30-30 issue on one issue regarding the date from 15 November to 5 January of 2022. Our position is that time period should be charged to the people.
Thank you.
Oh, that's it. Okay, yeah.